Here, my lord, the revenue has filed the appeal. In this, all the cases, your lordship has already recently issued an ITN number 120 of 2013 against the revenue. So this
Same order.
18th February. Same
All
order.
right. All right.
Same, 14 also same. Item 14.
All right. In view of the order.
1 and
passed-
14.
Yeah.
1 and 14, madam.
All right.
What should
In
be?
view of the order passed with this court on 18th February 2022 in ITA 120 of 2013, bracket Commissioner of Income Tax, bracket TDS Khurda versus Neelachal Ispat Nigam Limited. These appeals are also dismissed in the same terms. And item 14 also same.
Lordship, please.
Right.
Supplementary list item number 2.
May I please, your lords? The applicant in this case, my lord, has approached this honorable court against the notations 148 annexure 2 and 148 AB annexure 3. My lord. So far as annexure 2 is concerned, my lord, it has approved by the Joint Commission, or it has to be approved by the Principal Commission.
Ambika Iron and Steel.
So,
All right.
so far second it is concerned, my lord, they are issuing a notice basing on the Supreme Court decision, whereas it has been clarified by the civility circular, saying that if the proceeding is before 1/4/22, then
Who is
the
Mr.
Supreme Court
Chibanka?
issue notice.
Yes, my lord, yes.
Ah, so we can dispose it of in Ambika Iron?
Yes, my lord.
All right. The impugn notice in the present case having been issued with the previous sanction of the joint commission, joint CIT and not the CIT. It is unsustainable law in terms of the order passed with this court on 24 January 2022 in writ petition civil 20919 of 2021, bracket Ambika Iron and Steel Private Limited versus Principal Commissioner of Income Tax. Consequently, the impugn notice dated 31st March 2021 and all consequential proceedings and orders pursuant thereto hereby quashed. The
Yes.
writ is allowed in the above.
Annexure 3 to be passed basing on annexure 5.
All consequential proceedings. are set.
Supplementary list item number 3.
Lordships, item number 3, my lords,
Yes.
sister concern of the petitioner, Lordship have posted it to 15th of November. 15th of November.
Okay. List on 15 November along with STREV.
STREV 468 of 2008.
Okay. All right.
Supplementary list item number 4.
Please, my lord. Let it come dispute for removal of a defect, my lord.
Right. You will remove it in a week.
1 week.
Counsel, the petitioner says that he will remove the defects within 1 week. List thereafter.
Supplementary list item number 5.
May it please, Lordships. Here, my
Faceless.
lords, assessment year is 1314. And your Lordship will kindly see Annexure 1 at page 11. Here, your Lordship will kindly see the reopening has been made
After 4 years.
after 6 years.
Correct. Correct.
So
who's-
it is totally unsustainable.
So who is here?
Mr. Mahapatra, I have served the copy, my lords.
It's covered by our orders then.
Yes, my lords. That Ambika Iron, even though is not strictly applicable here, but so far as section 149 of the IT Act is concerned, that says the second one, 149B, it says that.
Lordship, pass it over, I'll inform.
All right. First.
Supplementary list item number 6.
6 also here, my lords, also it is covered by Ambika Iron. Lordship will kindly see assessment is 1516
Joint CIT.
and joint CIT has given the approval for reopening of the assessment, which is, my lords, I'm giving the judgment of Ambika Iron.
But then here who is here also Mahapatra?
Mahapatra is there.
I don't know where he is.
But he is in appealing the court here.
All right.
So
We'll pass over both these.
Yes, pass.
Let him come.
Supplementary item number 7.
Yes, Mr. Wad.
Well,
6 and 7 can't be located, no such person. Opposite party 6 and 7. The opposite party 6 and 7.
Seven, my lord, what has happened in this case
Ah,
is that the intermediary sold it in the year 1964.
aha,
Thereafter, they sold it to two other persons.
ah,
Then they sold it to another person who mortgaged it with a bank. my lord. In the bank, auction was held, and my father was the highest bidder, and I got that property. It was mutated in my name, records were issued. But at that time, no revision was there under 38B. Revision was initiated after 38 years. my lord.
oh,
And it was set aside without hearing me, giving notice to the original
I see.
intermediary. So I have other points, but
but
if
you can
your
go back. Should go back. All right. The
and your lordship may kindly observe that all the points available in the writ petition
yeah
can
will
be
be
urged.
urged. All right. The challenge in the present petition is to
Only your lordship may kindly see annexure 6 page 38.
yes, that's the order he wants.
Yes, no, there, your lordship can see that revision petition was filed in respect of 3 orders. Order dated 27/1963, 17/6/1964, and 5/8/1964. Well, his grievance is in respect of order dated 27/1963 only.
That's right.
All right.
Let it be confined to my case, my property.
All right.
Paragraph 7, he has stated, my lord senior has stated.
All right. So this has to go to the Board of Revenue again.
Member board of.
All right. Challenge the present petition is to an order dated 4th September 2004 of the Board of Revenue, Orissa, in OEA revision case number 21 of 1999, whereby the order dated 20th July 1963 passed by the Tahsildar cum OEA collector, Nimapada, was quashed, and the lands in question was stated to have vested with the government and the Tahsildar. Paragraph. One of the grounds of challenge is that the said order was passed without notice to the present petitioners, who were the purchasers from the original lessee,
So he was the purchaser in auction purchaser.
who was the auction purchaser, right? Way back in
Annexure 3. 6492.
way back on 6/4/1992. Full stop. The above fact is not disputed. Consequently, the impugned order is set aside on the short ground, and the matter being revision case number 21 of 1999 is remanded to the Board of Revenue Orissa to be heard afresh after giving the petitioner an opportunity to file a response and to be heard. The matter will now be listed before the OEA revision case number 21 of 99 will be listed before the Board of Revenue on 29th August 2022 for directions. The petitioner will remain present through counsel before the Board of Revenue on that date. All the grounds urged by the petitioner in the present petition are permitted to be urged before the member Board of Revenue, Orissa.
Only one line, my lord, that this annexure 6 is set aside so far as order dated 27/1963 is concerned.
It is clarified that the impugned order has been set aside insofar as it concerns the order dated 20th July 1963 of the Tahsildar cum OEA collector.
In claims case number 480.
In claim case
05960.
number 480 of 1959-60. Correct. All right.
Supplement.
Yes.
Supplementary list item number 8.
I have already lost the battle earlier. So I have to surrender.
All right. No, where is that? Where is that order?
Order, I think, Mr. Padi has, unfortunately, I don't have that. I lost the battle, so I don't keep. And the, I think, month of December, no, November, not December. I'll give the number, man.
All right. In view of the order passed with this court in STREV number so and so, the present petition is dismissed. All right.
If your lordship is not inconvenient, Mr. Mahapatra has come. If your lordship can
all right.
take 5 and 6.
All right.
5 and 6, man.
Right.
Mr. Mahapatra has come.
Huh.
5
Item number 5.
That 13, 14.
Yeah.
And annexer 1 is your lordship will have already seen that
It's more than
yes, beyond 6 years.
Yes. All right. The impugn notice under section 148 of the Income Tax Act
And also the assessment order.
seeking to reopen the assessment for AY 2013-14 was issued on 31st March 2021. That is beyond the period of 6 years
Yes.
on after the close of the assessment year, and therefore is clearly time barred. On that short ground, the impugn notice as well as all consequential proceedings thereto, including the
Assessment order matters. Annexer 2 and 2A. 2 by 8.
assessment order
Annexer
dated 30th March 2022 and the consequential demand are hereby quashed. The petition is allowed in the above terms.
and
Item 6,
6 is, my lords, that Ambika iron is squarely covered.
correct. Insofar as the impugn notice dated 21st April 2021 has been issued
Annexer 1, man.
with the previous sanction of the joint CIT and not the principal CIT. Following the decision dated 24th January 2022 of this court in WP Civil 20919 of 2021, bracket Ambika Irons and Steel Private Limited as Principal Commissioner of Income Tax. The impugn notice and all
Annexer
Consequential
1
orders.
at page 9.
and all consequential proceedings and orders are hereby quashed.
My lords. And the assessment order is 1. Sorry, sir.
No,
Sorry.
not this one.
Only Annexer 1.
Correct.
Annexer 1 is
Notice is
quick
only notice.
first. Only notice. Yes.
Right.
Only notice. I'm
Correct.
sorry.
Correct. All right.
Obliging.
And both the matters my appearance.
Yes, yes. We're waiting for you only. Right.
Supplementary list item number 9.
May I please, your lords?
Yes.
In this case, the annexer 3 is the impugned minors, the order passed by the Tahsildar.
Huh.
With the Orissa scheduled area transfer of immovable property, scheduled tribes regulation 2 matter minors. Law has already been settled by this honorable court minors. The remitting back to the Tahsildar as this honorable court observed that the amendment made that should be effectively respectably matters. So this honorable court in various cases remanded the matter to the Tahsildar to reconsider the made in observation in these judgment matters.
Which judgment, sir?
That is 2019 2LR page 94.
Give us the book at least.
Observation made in para 13 and 12 and 13 matters. The amendment
Regulation will have a prospective effect.
He has not filed the return, which is required to be filed.
you cannot necessarily take the amendment much prior to the.
So you are also purchasers from
Much prior to the amendment matters.
Yes.
Since in 1986 matters.
all right. The challenge in the present petition is to an order dated 22nd June 2009 passed by the officer on special duty
My lord, so order dated 29/3/2010, my lord, at page
So who
70.
was passed? Order officer in special LR Baliguda.
Officer in special.
Actually, sub-collector is the authority. Perhaps he is assigned with the job of dealing with the case at that particular point of time.
Okay. Order dated 29th March 2010. Passed by the sub-collector. No, head clerk.
OSD LR. Officer in special duty LR, my lord.
Passed by the OSD bracket LR. Baliguda. Restoring the land in question to the, who's the first party? Who's the first party, sir? Just restore to the first party.
My lord,
The order says the land is restored to the first party. Who's the
Ma'am.
first party?
has to be the opposite party number 5, my lords. With the
The
owner of-
vendor.
vendor.
To the first party, that is the vendor, who's implemented here as opposite party number 5. Paragraph. While directing notice to issue the present petition on 28 September 2010, this court had directed that there will be a stay of the impugned order, which was passed in RMC number 221 of 2009. Full stop. For nearly 12 years now, no reply has been filed by any of the opposite parties. Concept the petitioner relies on points out that the petitioner is a purchaser of the suit land much prior to the amendment regulation, much prior to the Orissa scheduled transfer of immovable property bracket by scheduled tribes bracket amendment regulation 2000 bracket hereafter amendment regulation 2000, which has been held by this court in Jami Ramesh versus State of Orissa 2019 2 OLR 94 to only have prospective effect. Stop. He states that the impugned order has been passed without affording the petitioner an opportunity of being heard. Full stop. Paragraph. The above contentions are not disputed. Consequently, in view of the judgment of this court in Jami Ramesh versus State Supra, the impugned order dated 29th March 2010, passed by the OSD LR Baliguda in RMC number 221 of 2009 is hereby set aside. And the said RMC number 221 of 2009 is restored to the file of the OSD LR Baliguda and will be listed there for directions on 29th August 2022, on which date the petitioner shall remain present in person before the officer along with a certified copy of this order.
May I request your lordship to say that sub-collector, because that particular office may not be, because sub-collector is the head.
I
He
see.
is to deal with all these cases.
Or it will be listed before the sub-collector Baliguda. Bracket opposite party number 3. And all the others. It is clear that the all other contentions of the petitioner as urged in the present petition will be permitted to be urged before the sub-collector in accordance with law. The writ petition is disposed of in the above terms. You said till such time the sub-collector is requested to dispose of the said RMC case within a period of 6 months thereafter. Until such time, the status quo as of today shall be maintained. All right. The petition is disposed of in the above terms.
Supplementary list item number 10.
Item 10, on the last occasion on 4/4/2022, my lord directed me to file an affidavit explaining the basis for fixation of the cut-off date as 1/12/2008. Though I have received the instruction, but I could not file the affidavit. Lordship, grant me short time.
Mr. Mudri seeks and is granted 2 weeks' time to file an affidavit in terms of the order dated 4th April 2022. Rejoinder thereto, if any, be filed for the next date. 5th September.
Supplementary list item 11. Item number 11.
On behalf of Mr. Ponda, this matter has become infructuous.
Counsel for the petitioner states that the petition has been rendered infructuous. It is disposed of.
Supplementary list item number 12. Item 12.
Well. This is, I am giving a short date chart. This is in regard to step of pay of a driver working under your lordship judicature. His junior is getting a higher scale. I am getting lesser scale, my lord. A short date chart. Let me see at least the order of rejection. They have rejected page 20, annex 9, my lord. They have rejected based upon the para 5 of the resolution of the finance department, my lord. But my case is that same resolution, para 7 note 2, my lord.
Which page?
My lord, that is page 30. My lord, note 2, your let me see. It says that it has to be step up since junior employee is getting a higher scale. Page 30, my lord.
Yes.
My lord, note 2, let me see.
Yes.
Shall I place, my lord?
Yes, yes.
Where a fixation of pay under sub-rule 1, the pay of a government servant who is existing share drawing immediately for 1/2006, more than pay of another servant junior to him in the same grade, same cadre, he belongs to get fixed revised pay band at the stage lower than junior. His pay shall be stepped up to the same stage in the revised pay band, my lord. My lord, this point also, you know, come to their counter page 7, my lord. In their counter, they filed the office note. The office also clarified that. Page 7 of the counter, my lord.
Yes.
Let me give clarification part. Let me see. For example, a employee is an employee who has promoted the post of 2000 without availing SCP or SCP 2008. His junior got promotion to the same post on 10/12/2006. After availing SCP, his pay in the revised pay structure has become more than senior A on the date his promotion. In such a case, pay of a senior employee A can be stepped up. That of a junior B on the date of promotion of a junior B. Well, they have clarified, but while rejecting, they have adopted no 5. I could not get from the get it annex 9, my lord. The order of one line rejection. I failed to understand how a junior employee will get a higher scale and the senior will get lesser scale. Annex 9 will receive one line order of rejection, my lord.
Yes.
In fact, he is claiming parity with one Dibakar Mishra.
Who's junior to him?
No, his claim is that he is junior to him.
No, but in your counter, have you denied it?
No, here, my lord, the facts are this. The petitioner was regularized as a driver only by the annexure 6. That is from with effect from 11/3/2004. Prior to this, he was appointed as a regular class 4 employee at Dibakar Mishra. And subsequently, he was promoted to the post of driver. Well, his pay was protected, whereas the petitioner was directly appointed as a driver. That is our case. May I place a paragraph 6, let's see, running page 49.
No, but that Dibakar is junior to this petitioner. That's the whole basis of the case, that he's junior to him and yet he's getting a higher pay. That can't be denied, Mr. Mudali.
He got in 2012. I am 2004, my lord.
Okay, the petitioner was presently working as a driver in this court. Has filed this petition with a direction to step up his pay on par with one Dibakar
Only Your
Mishra.
Worship, can see paragraph 8 of our counter, Your Worship.
Yes,
The running page 51.
yes.
It may not be out of place to mention that in view of Orissa High Court Appointment of Staff Amendment Rules 2010 and Rules 2011, Sri Dibakar Mishra along with 5 other class 4 employees of the court were promoted to the post of driver in the scale of pay 5,200 to 20,200 with grade pay of 1,900 by the office order dated 5/12/2012. Consequent upon promotion and joining of Sri Dibakar Mishra as driver with effect from 6/12/2012, the pay of Sri Mishra has been fixed at the stage of rupees 8,080 pursuant to Rule 13(1) of ORSP Rule 2008 in the scale of pay 5,200, 20,200 with grade pay of 1,900. By the time of promotion of Sri Dibakar Mishra, the petitioner who had earlier joined in the post of driver was drawing his pay at the stage of 7,630 with effect of 1/3/2012 in the scale of 5,200 to 20,200 and grade pay of 1,900.
So you're not denying the facts. The other person is junior to him.
That is there.
Ah,
Subsequently, he has joined the post
Yeah.
of driver.
the prayer for two directions. One is to step up the pay of the petitioner at par with a junior driver, Sri Dibakar Mishra, or refix the scale of pay under Rule 74 bracket small b of the Orissa Service Code with effect from 11th March 2004, the date of promotion of the petitioner from peon to driver. Paragraph. In response to the notice issued in the present petition, a counter affidavit has been filed on behalf of the opposite parties, in which in para 8 it's stated as under page 51.
Paragraph 6 also we have stated there.
Sorry,
In paragraph 6 also, page 50. Page 50, got last. 8th line from the bottom, since the regulation of the service of its.
yes, yes. Of the service of the petitioner driver, it's been taken. Paragraph. The further averment in para 6 of the counter affidavit. Also does not dispute the fact that Sri Dibakar Mishra is junior to the petitioner and yet is drawing a higher scale of pay. Paragraph. With the facts not being in dispute, it is obvious that the petitioner has been getting a pay less than Sri Dibakar Mishra, who is admittedly junior to him. Stop. Since the admitted facts, the facts are admitted, namely that Shri Dibakar Mishra was junior to the petitioner and yet was getting his pay at a scale of 8080 as on 1/1/13/2013. The petitioner was getting a scale of 7920. Stop. The petitioner being senior to Shri Dibakar Mishra is entitled in terms of the where is that rule that you were reading, sir?
My lord,
That rule which says step up.
7 note 2, my lord, page 30.
in terms of note 2.
Well, in fact, this note 2 will not be applicable to the petitioner. Because this not only provides the junior, you also can say the language is where in the fixation of pay under Schedule 1, the pay of a government servant who in the existing scale was drawing immediately before 1st day of January 2006 more pay than another government servant junior to in the same grade.
The same grade, sir.
No, driver, he came to the junior person became the driver in 2012. Driver promise.
Let's see the chart. He is 2005 apprentice, I am 2004. He came to 2012 by that. How, my lord, he is objecting, he is admittedly junior in their records wise.
In note 2, in terms of note 2 to note 2 below rule 7 bracket 3 of the OSRP rules 2008. A direction is issued. Accordingly, a direction is issued to the opposite parties to refix the scale of pay of the petitioner with effect from 11th March 2004 on par with the pay given to the Bakar Mishra under in terms of rule 74 bracket B of the Orissa Service Code. The necessary orders be issued and the arrears be paid to the petitioner within a period of 8 weeks from today. The petition is disposed of in the above terms.
Supplementary list item number 15.
Lordship has already issued notice in this case. Here the case is not whether the penalty under section 171D is imposed on the assessee for contravention of section 269 cases. Related fact remain is the Lordship see the assessment order running page start from running page 17. Throughout the year, my lord, he has accepting the cash. Not only single occasion or 2 or 3 occasions. All these lot of she running page 17, start from 17, next page 18. 1,70,000. 1,70,000. He has collected cash. And without a reasonable why he has been accepted cash. He stated that the person is sitting in a remote area and the modus operandi his business is a labor contract, so he's need a money. But fact remains all this company has registered a Bhubaneswar office at Bhubaneswar. And there is a bank facilities there. Therefore, you see your lordship, the tribunal is says quoting the order of the commissioner. And interestingly, commissioner has and the commissioner tribunal held that it is not permissible and deleted the penalty amount on the ground that the person is not conversant with the Income Tax Act. This company is not having so many professionals.
No substantial question of law in these things. It's just a discretion.
No, it's not discretion. There is Act never said discretion. It is mandatory. If is not accepted to more than 20,000, he has to pay the penalty. That is section. Your lordship kindly have a glance at the section itself. 216 is. My lord, may I place that? And I supported by 2 judgment of the High Court. If it's a regional.
Now come to page 19. Let's see the finding of the tribunal.
Yes.
Para 6.
Years.
Page 19. The running page is 1.
Yes.
Para 6.
Para 6. We heard the rival submission. Tribunal order, lordship. Tribunal order, lordship. Para 6.
Yes.
We have heard the rival submission, perused the orders of the lower authority and material available on record. In instant case, the asset receives unsecured loan of rupees so and so crores from two sister concern. The said loan accepted as genuine after verification by the assessing officer in the assessment order. By the order dated 19/3/2016. Therefore, the assessor levied penalty under 17D of the Act, violation of provision under section 269 SS of the Act by accident loan exceeding 20,000 in the case. On appeal, CIT did a penalty following decision of Mumbai bench of the tribunal in case of KK Enterprises Supra and Calcutta benches tribunal in so and so. This quoted the tribunal's order and held that this penalty is not imposable, not to be imposed.
Correct.
Well,
What is
my
wrong with-
submission is that penalty proceeding is separate proceeding. It is not to be considered the assessment because he has to take permission to the higher authority for initiate the proceeding or the penalty under section 271D. So it cannot be a same proceeding. He may accept it in the assessment that he is not questioning the cash deposit, but the penal proceeding is separate proceeding initiated by the authority by approval from the higher authority. So it is two proceeding. It cannot be same proceeding. That is referred in the assessment or you see. I may not be questioning if you know 2-3 occasions it has been taken loan. I have no question. You also see the running page 17 and 2. Series of date, all the date. It is only MI said it is a book chart, nothing more than that.
Which
all,
page?
Running page 17, assessment order, annexure 2. See the entries, Lord. All these entries you will also see date from April to 2008 August. All the dates he has been accepted. And the AO was categorically held that mostly both the companies, the sister concern, both the company, a registered office at Bhubaneswar. So bank transaction are there. He could have transferred from, even if he is assuming he has need of money of anything, he can transfer it from bank. It is not the case that he is an ignorant person or somebody else. And the finding of the established that he is not aware of the section. It is very interesting to therefore admit an issue notice to form the question of law. Only issue notice, Your Lordship. On that day, Your Lordship, only issue notice.
Yeah,
May I
what is
permit-
it?
Lordship, with due respect to your lordships, I may be satisfied with this honorable bench ballots. If your lordship permit me, 2 to
Yes,
3
yes,
minutes.
yes, yes.
ballots.
Carry on.
Yes. My lords, the respondent assessees engaged in the business of my lords, labor supply my lords, and work site at remote area in the district of 3 districts my lords, Ongul, Raigada, and Sundargarh my lords. Lordship, fact is that due to uninterrupted cooperation at work site my lords, the assessee company my lords had raised funds from 2 nurse sister company my lords. Both the 2 nurse sister companies, but my learned senior is saying that he is a company. No, they are partnership firms, my lords, and under the same roof, my lords, and lordship amount borrowed from 2 sister concern, one concern, my lords, 1.50 crores, and another 20 lakhs, my lords, totaling to 1.70 lakh, my lords. In these sister concern, my lords, managing director and director of this assessee company, respondent assessee company, are partners, my lords, wherein stakeholding, my lords, 55% in jointly, my lords. Both the husband and wife, managing director, are partners in that sister concern, my lords, in both the sister concern, my lords. Lordship, the entire decision, to raise funds and transfer funds from one person to another person, lordship, have been made by this managing director of this concern, since it's a family managed business, my lords. Lordships, the case of the respondent mailers is that the payment was required to be made to laborers mailers and at the worksite mailers, and for that reason, your lordship, cash has been withdrawn from bank accounts of the sister concerns, and thereafter, your lordship, that has been passed to worksite and your lordships, and this is only because, my lord, this is only because of insufficient of funds in my hands or assessee company's hands, my lords. My lords, all the transactions, whatever the transaction 1.70, lordships passed through journal entries, my lords. My lords are well aware of, my lords, that in the assessee's books of accounts, my lords, labor charges account debit and crediting to sister concern accounts. And so far, assessee, my lords, sister concern is entry is concerned, my lords. This is assessee company account debit, crediting to cash bank account. So, lordship, entire transactions has duly been disclosed and reflected in the balance sheet. In sister concern accounts, it is asset sides of the balance sheet, loans and advances to
assessee company, and lordship vis-a-vis in assessee company's accounts, your lordship it is under the liability sets in the balance sheets. Entire all these both these sister concerned matters are income tax assessing and file their income regularly and file along with the balance sheet matters. Disclose all entire things disclosed before this authority matters. Lordship fact is that the learned assessing officer matters, while passing the assessment order under section 143 of the Act matters, has not disputed any genuineness of the transaction. What my learned senior is saying that no genuineness of the transaction has not disputed matters. Nothing. If your lordships, no addition has been made on this transaction 172, no addition matters have been made in the assessment order matters. So lordships, matter right now, so thereafter your lordship section 269 in contravention to section 269 SS matters, learned assessing officer initiated LNT under section 271 capital D of the Act. Matters on account of jurisdiction matters, additional commissioner passed the assessment or penalty order under section 271 D matters. Thereafter matters, assessee gone for appeal before the Honorable Commissioner of Income Tax Appeal matters. Honorable Commissioner of Income Tax Appeal matters, this is important. Honorable Commissioner of Income Tax found that the sister concerns paid this money towards labor payment at remote site. This is findings, matters, CIT order page number 9 matters, and all the transactions are genuine in nature, and the AO accepted the same. This is important matters. So lordship also matters, the learned Commissioner of Income Tax Appeal matters also observed that due to business expediency matters, this assessee compelled to do so, and also matters, the SS Parida, who is looking after all these things matters, is not aware of this transaction. Since it is a family management, the transaction from one person to another person will involve section 261. He is not aware. Moreover, your lordship, what my learned senior is ignoring this fact, lordship section 263 capital B of the Act, matters is a curable section benefit to the assessee. Invoking this section 273 capital B of the Act matters, the learned Commissioner of Income Tax passed this order of being it is a reasonable cause. So lordship, this is the findings of the learned Commissioner of Income Tax Office.
Your lordship, I am relying on your judgment, your lordship.
All right, all right.
Lordship, I may
All right.
duplicate.
Is there no substantial question of law arises, the petition, the appeal is dismissed. All right. We'll
Supplementary,
pass the detailed order. You'll get it on Monday or two.
Your lordship, yes.
Right.
supplementary list item number 16.
May I please, your lordship? Sir, my lord, I have challenged the creation of Sansara at your lordships in violation of the state guidelines, my lord, under Annex of. Your lordship may kindly turn to page 14.
Yeah, affidavit may kindly be seen, which I have filed pursuant to your lordship's direction. That is on 7th April 2022. That will suffice it, para 5.
There are 5 of the counter.
No, counter, yes, my lord.
Para 5 of the affidavit, my lord and friend is trying to say
No, affidavit which I have
Affidavit
filed pursuant to your lordship's direction.
7/4/2022, that will not suffice the court.
So why don't you say para 5?
My lord.
Para 5 the counter, sir.
My lord, your lordship may kindly see page 7 of the counter which has been filed by the State Council.
No, but why don't you read para 5?
Yes, I have gotten through, my lord. That is mining, approval of mining plan. But that was not the direction of this honorable. But your lordship may kindly turn to page 4 of the counter. That is para 7, sorry, page 3 of the counter, para 7 of the counter filed by the state, your lordship. I may be permitted to read this. That it is respectfully submitted that the objection petition filed by Sarpanch of Purohitpur GP and others was heard on 31st 10/2019 in presence of the objectors. The Sarpanch along with the committee members made objection regarding possibility of creation of leaking point in the river embankment due to plying of sand loaded vehicle over it. If the source will be leased out, further they stated that there was one leaking point, Ghalia, my lord, in the river embankment at the time of high flood and created havoc to the nearby people. The objectors opposed auction sale of the sand source. Thereafter, your lordship. It is pertinent to mention here that the aforesaid being the allegation on the possibility danger to the river embankment, accordingly, necessary correspondence was made to Irrigation Authorities Rural Works Division Bhubaneswar for submission of their considered views on safety of river embankment and its road at such and such, your lordships. That has not been got. That was the direction of your lordships.
No.
The only what was the report of that irrigation department?
No, that
And
direction
whenever my lord
is
said
to-
that there is, please, sir. In the meantime, Director Geo Consultant Private Limited, Kotak Road, Bhubaneswar, was requested to submit approved mining plan of the source by this office letter number such and such. However, after receipt of the report from the technical person, action as deemed fit and proper will be taken on the allegation of the objectors. So now mining plan was approved, but there is no report submitted by the irrigation department. That was the earlier direction of this honorable.
What is the position today? This is 2019 petition.
That is the last sentence. It is pertinent to mention that the source is not operating in view of the pendency of the present litigation.
It was a newly created source, your lordships. Not that it was a
Yes,
continuing
it is a
source.
newly
It is a
created and
newly created source.
All formalities have been
My
made.
lord, the very particularly your lordship, your lordship will find annex or 2 that your lordship may kindly see page 14 B. Mining plan and environment clearance approvals. Tahsildar competent authorities shall get the mining plans prepared in the advance through registered qualified persons in respect of the sources within his jurisdiction. While preparing mining plan, the distance of hydraulic sources, including dams, barrages, check dams, bridges, location from habitations, habitat sites, monuments, and public infrastructure facilities should be taken into consideration. Sand quarrying operations should not endanger the safety of the structures and imperil the lives of the people. This is not at all considered. I have made allegation against this clause, these activities of in respect of this clause. There are monuments and other things are there, and dams, heritages, everything is around that.
Third, after considering all these formalities, we have decided to create a source of.
They have not said whispered a single word in respect of that in the count.
And so far as that irrigation part is concerned, if your lordship will say within 7 days, I will get the instruction. What is the what has happened, my lord? Whenever we make any new source, some people of the villagers, there are other sources nearby. They don't want that new source should be created so that their business, that is you please, so that their source will be business in their source will be hampered. So they engaged all these things, and by doing here, there is EC clearance, environment clearance, all formalities have been cleared, and for government revenue purpose, we are creating this source, and these are the, and if at all your lordship will say, so far as that part is concerned, irrigation executive engineer part, I will get instruction and file it within 7 days. But there is absolutely no cause of action for this petitioner to come forward with a public interest litigation to stop this source after the environment clearance is obtained.
You know, may kindly see whatever the allegations I have made in the data. It is completely contravention to their own guidelines. And they have admitted in admission their counter. They have not done. Thereafter, after my lord, whenever your lordship was pleased to issue notice to the authorities, thereafter they have done. They're trying to do something else.
And I have specifically mentioned that there was unauthorized lifting of sand from that particular area. That is why we decided to legally carry out the operation. These people who are involved in this illegal activities, they set up this PIL, and anyway, this is going on. But my submission is that after the environment clearance, no more apprehension should be on the part of the petitioners that there is something, because the environment clearance is the main factor.
Sarpanch of the locality, my lord, has objected. He has also filed representation. That was also pending. Moreover, my lord, Sarpanch has intervened before your lordships. In fact, my lord, the lawyer for Sarpanch is not today, my lord, I do not know. But earlier dates, my lord, the advocates appearing on behalf of Sarpanch was there. And moreover, my lord, that is in my lord
Not that
counter,
whatever
your lordship
the
will find
Sarpanch
that
will say, that
the
is-
grievance is made by Sarpanch itself.
But whether
There
that
is Ghalia in
Sarpanch
the embankment. And there is no consideration of this, my lord, the two temples are there. In between, only
I
200
don't
meters from
understand
that.
if temples are there, then the source will not operate. I don't understand
my lord,
how it is. Because
that is
in
your
many
guideline.
sources, temples are nearby, temples, villages, everything is there. And it is the responsibility of the lessee to get a free access to the source and lift the sand. Let them approach the collector if they have so many grievance. But
will not
question is, I respectfully submit that discontinuation of this source will otherwise affect the government revenue. That is all.
All right. See, we're not inclined to interfere, sir. We'll pass the detailed order. All right. Petition is dismissed.
Supplementary list item note 17.
Your lordship may say I will file representation before the collector, that will be dealt with according to the law.
70.
Representation regarding what?
My lord, the creation of
That
No,
is
no,
already,
that's the whole.
we have already
they have
taken a
second
decision
round.
what
no,
representation.
my lord, what has happened in this case? In fact, my lord, your lordship was directed to the my lord to take instruction what executive engineer irrigation has my lord
No, there is
revealed
no
from
such
that annex
specific
2.
direction. You go through the past
Yes,
order.
that
There
is
is no
what is the
specific
report of
note.
it. As it says, your lordship may see annex 2 for a
Anyway,
clause
that-
A.
Sir, we've already
Is already
passed the
over.
order. We can't go on hearing like this, sir. Thank you. You heard you at length.
Obliged.
Supplementary list item number 17.
Please, my lords. My lords, I filed a counter affidavit pursuant to the orders. The issue, my lords, if I may summarize, is that
My lord, only 7 withdraw, my lord.
Okay. Counsel, the petitioner seeks leave to withdraw this petition. Dismiss this withdrawal. All right.
Supplementary item 18.
Item 18.
Yes.
Item 18, I have raised two issues before your lordship. This is a PIL. The government is trying to acquire the land belongs to the Soilawala Women's College. I have raised two issues. Number one, whether the government, being a secular, can take the land of an educational institution for a particular religion. That is one. And two, this being a monumental institution, it is the duty of the government to protect. That I have raised only two issues. My lord, admittedly, the institution was of the year 1913. This is the first women institution of the state and third in India. And the land was donated by the daughter of late Madhusudan Das for establishment of the college. So in this...
No, is this, you're only going by a newspaper item?
No, newspaper, and after that we have also approached them. That is Annexure 4.
No, that Annexure 4 only I'm reading.
My lord?
Annexure 4, para 1, as
Yes.
per the critical assessment and information of press media.
Yes.
So you're only going by media reports.
My lord, because we don't have any other sources. And once your lordship intervene in the matter and direct the state government.
No, what is the announcement made, Annexure 3? Again, it's a newspaper cutting.
Yes, my lord. My lord, and
what are instructions, Mr. Monty?
Yes, my lord. I have filed certain documents. I pray your lordship to.
That document has been.
Yes, I have supplied the document just
has been
half an hour before, but I may be permitted to place it.
Yes.
Your lordship may kindly see. This is a project floated by the state government for beautification of the Katak Chandi temple, which is the main architectural and most religious institution of Katak. All the sentiment of Katak people are on this Katak Chandi temple. The government has decided to invest a huge amount for the development purpose of this temple. And by the by, what my learned senior is saying, that you are acquiring the land of this SB Women's College. That is not correct. We are not going to acquire any land. The land which is government land recorded in Rakhit Kata, which is used as a part of the playground of the SB Women's College, a very small portion. I have given the sketch map. I will place before your lordship, is used for road purpose, diversion of road purpose. In front of the Katak Chandi temple, this college is situated. I will draw your lordship's attention to the document which I have filed. First document
Why is she saying for some religious purpose? And
my lord,
she's saying it's going to be
It is
used for some religious purpose.
no, religious. No, it is a monument of Katak city, and for beautification and for development of Katak Chandi temple, we are doing this project work. That is all. Your lordship may kindly have a glance over the first document. This is the R&R package
My lord,
for first document.
my lord, with your lordship's permission, my lord, with your lordship's permission, just upon our back, the copy has been served upon me.
Yes.
May I request your lordship to keep it to Monday so that let me go through it, and the main question that has not been answered, only documents have been filed.
No, because notice was not issued. This is the first time it's
Yes,
coming up.
no, it has come earlier, before the.
It has come earlier. And the Honorable Court has said that you filed the sketch map. Just kindly give me 1-2 minutes time. I will explain before a lordship. I will just place the records.
Before the Honorable Vacation Judge.
Let her take time for response, but I will place certain records before lordship. Your lordship may kindly see. First document is this R&R package. The next document that is most important, minutes of the meeting for integrated development of Ma Katak Chandi temple and its premises.
But the order was that you should file a detailed affidavit.
Yes, my lord. I will file a detailed affidavit.
Or Mr. D.K. Mohanty has handed over a set of documents and a copy has been provided to learned counsel, the petitioner. Full stop. In terms of the order dated 2nd June 20, Mr. Mohanty states that he will, in terms of the order dated 2nd June 2022, be filing a detailed affidavit explaining the said documents within 1 week.
Within 2-3 days. Next week, your lordship.
Yeah, within 1 week, with an advance copy to counsel for the petitioner. List on 19 July.
My lord, the short date may be fixed. Because next week I will file on Saturday. I will serve copy.
There's no interim order.
No interim order.
My lord, no interim order, but your lordship may direct them not to encroach.
Encroach?
Encroach.
What
It
is
is government land. Government land.
My lord, question is
Encroach.
not. My
It is
lord,
the government land.
my lord,
Who are they?
naturally-
They have no local standing.
My lord,
It is
that is-
our land. I have
our,
filed the record of right.
my lord, our land means it is a government institution. Once
Let it come on 19 July.
Yes.
Obliged.
Right.
Supplementary list for hearing item number 19.
May I be?
Yes, please.
So conviction,
Yes.
sole appellant,
Yes.
has been convicted under section 304B, 498A, 302, and
Yes.
4 of the DPI.
Yes.
Was charged under these sections and conviction under all these sections. On the basis of a affair lodged by the informant, my lord, BW1, before the officer in charge of Lingaraj police station, my lord, a case was registered. And the prosecution case is my lord, that on the date of occurrence, this appellant, my lord, this appellant who is the sole accused, he was on the date of occurrence, his wife was found dead in his house. My lord, one person, except his 2 children, my lord, one person was sleeping in that house and he is the sole eyewitness to the incident because he has seen the incident and he was sleeping in the house itself. The house in which this dead body was found, dead body of the present appellant was found, that house belongs to this appellant. He was staying with his wife, 2 children, and another relation's, my lord, nephew, sister's son, was also staying in the same house. And also, my lord, by the same corridor, by the same passage, 2 other houses were there. And one of the persons belonging to the other house, neighboring house, my lord,
he lost the affair, and the police came to the spot on the basis of a telephone message or something like that. Thereafter, he lost the affair, my lord, saying that my wife was found dead. And thereafter, my lord, the police entered inside the house and found that my wife was assaulted, and that thereafter she's dead. Thereafter, my lord, he was very much present. This appellant, along with his two children, he was never absconded. He was very much present, my lord, being panicked. As per the prosecution, being panicked, my lord, he was present in another house room. And after the police came and knocked the door, he came out with the two children and also found that his wife is dead. Thereafter, my lord, on the basis of the affair lost by BW1, my lord, Trupti Das, a case was registered under section 302 IPC. During investigation, my lord, it was found that the the appellant was also demanding certain, my lord, financial assistance from her father's house, father-in-law, my lord, to construct a latrine and for this education of the children. That is the prosecution case, my lord, for which, my lord, 304B was added. Although this was not specifically for torture on account of demand of dowry, but 304B was also added, my lord. So charge was framed under section 302, 304B, 498A, and 4 of the DPI. And, my lord, in the process, my lord, and after the charge was framed, my lord, trial was commenced. And in trial, my lord, 19 witnesses were examined. Your lords may kindly see paperwork at page 89, my lord. As page 67, my lord, 19 witnesses were examined. Out of 19 witnesses, my lord, your lordship will find I'm just giving the brief, my lord.
No, 3 defense witnesses were also examined.
Pardon?
3 defense witnesses were also examined.
Yes, I'm obliged. 3 defense witnesses, the 3 witnesses for the defense, and, my lord, 19 for the prosecution. And your lordship will find at page 5 of the paperwork in my appeal memo, I have described a short description of the witnesses and the role they have played and the point on which they have deposed, my lord. Your lordship may kindly see page 5, my lord, of the paperwork, para 4, that the prosecution examined 19 witnesses, whereas the defense examined 3 witnesses, my lord. I mentioned that. Widow 1, Trupti Ranjana Das, is the co-villager of the appellant, and he orally lost the first information report. This witness is a seizure witness, the seizure of the chadar, iron rod, paniki, blood-stained earth, 1 plastic bag. This witness is also a witness to inquest. So, my lord, although he is the informant in the case, and although he lost the information immediately after the occurrence, but he is not an eyewitness. He never claims himself to an eyewitness. He is not an eyewitness. Widow 2, my lord, Prafullo Kumar Mahanti.
This must be a case of circumstantial evidence.
This is a case of circumstantial evidence.
Where's question of eyewitness then?
My respectful submission, my lord, where the case can be proved either by direct eyewitnesses or by circumstantial
evidence. Is this a
evidence.
case of direct eyewitness or is it a case of circumstantial evidence?
Yes, ma'am. Here is a case where there is an eyewitness available. Your lordship may kindly see. PW8.
No. What is the prosecution's case, sir? Have they projected this as a case of direct evidence or they're projecting it as a case of circumstantial evidence?
My lord, both.
How can it be both?
Your lordship,
please.
Ultimately, they have convicted.
What is all this?
Ultimately, they have convicted on the basis of. Ultimately, they have convicted my lord on the basis of circumstantial evidence.
Then that is what it is, sir. It is a case of circumstantial evidence.
What my respectful submission, my lord, where there is an eyewitness available,
you're admitting that there is an eyewitness to your crime.
Yes.
What are you talking? You're admitting that the crime committed where you had an eyewitness.
Pardon?
Are you admitting that there was an eyewitness to the crime committed?
Yes.
Who according to you is the eyewitness?
PW8.
Let's examine PW. Let's see what PW8 says.
Page 89, my lord.
Turn hostile, being a nephew.
That's the whole thing.
Maybe, my lord, hostile witness cannot claim that he is an eyewitness, my lord. My lord,
anyway,
your lordship's
the prosecution is entitled.
Your lordship's question to
me to prove the case as one of circumstantial evidence.
Your lordship's question.
If the eyewitness is turned hostile, if the so-called projected eyewitness is turned hostile, why cannot the prosecution show circumstances that prove the case?
No, your lordship's question to me whether there is an eyewitness to the incident or not. My answer is answer
So let
to your
us
lordship.
examine, let us.
My
because-
lordship's, my answer to your lordship's query, there is an eyewitness, but who doesn't support the prosecution case.
Right.
So my respectful submission, my lord, if there is an eyewitness who doesn't support the prosecution case,
Yes.
whether the case should be disbelieved or should be still convicted on the basis of circumstantial evidence.
Why
but the
not?
eyewitness was
Why
very much
not?
present
Why not?
and he did not support the prosecution
Why
case.
not? Why not?
Then your
There are
lordship kindly
circumstances that prove to
Pardon?
point to the guilt. Why can't the case be proved through circumstantial?
And coming, I never say that my lord, if the eyewitness doesn't support there cannot be a conviction on the basis of circumstances. I will also explain the circumstances, my lord. I will also explain the circumstances, and the prosecution has not been able to prove the circumstantial evidence, the principle, my lord, all the chain of circumstances, all the links should be proved, my lord. That has not been done. That also I'll point out to your lordship. But so far, my respectful submission initially was, my lord, and my respectful submission is that.
Let's read PW 8 now.
Yes. 89, my lord. The accused is my maternal uncle. My aunt, the wife of the accused, is dead. The accused belongs to village Gopinathpur. I sleep in the night in the house of the accused at Gopinathpur. The accused and his wife and 2 children were staying in the same house. When the wife of the accused died, his elder children was 4 years old and younger children was 2.5 years old. The house of the accused consists of 2 rooms. One is living room and the other is a kitchen. I sleep in the kitchen on a cot. On 7/7/97, also I had been to that house to sleep at about 9:30 to 10 p.m. When I went to the electric bulb was burning in the house of the accused, and 4 persons who were in the house, this is important, 4 persons who were in that house started running towards Bari side. The house was facing towards Bari side. I cannot identify those persons. The 4 persons started running. Just I was on the pinda. Pinda means veranda. Pinda. And when I went to the kitchen, I found that the wife of the accused was lying on the cot where I used to sleep with bleeding injuries, her persons, and was unconscious. So he had seen 4 persons.
1 minute, sir. Just read first and then make your comments.
Yes, madam. Then I ran away to my house shouting. I went to my house and told to my parents that my aunt was lying unconscious and there was blood at the spot. There she was lying. Hearing my shouts, villagers came to the house of the accused. I cannot say my parents went to the house of the accused or not, but I slept in my house. I do not know anything about the dispute between the accused and his wife. And he was declared hostile, my lord, and cross-examined by the prosecutions that I have been examined by the IO. It is not a fact that I have not stated before the IO that while I went to the pinda of the house of accused, 4 persons ran away from the house of the accused. This is not a fact that I have started before the IO, that the accused asked his wife to bring money from her parents' house for construction of a wall and latrine. And when she disagreed, the accused was unhappy with her and had called her brother. It is not a fact that being instigated by the accused, I am deposing falsehood. It is not a fact that being tortured, being tutored by the accused, I am introduced to a false story that 4 persons.
You never told the police.
That 4 persons were running away from the house of the accused. It is not a fact that I have started before the IO. I have stated before the IO. I have stated before the IO that no light was burning.
Sir, his 161 is there.
Yes.
Does he talk about these 4 persons in that 161?
He said, I have stated about the police.
Sir, you tell us in that 161, has he said anything about 4 persons?
That while I'll have to check up from the LCR.
What do you mean? Of course you should know, sir.
But the moment I'll come to page 134.
161 statement usually is not available.
134. The IO has been confronted.
I'll check up from the LCR.
134.
Yes, boss. Paragraph 28.
I have examined PW8. He has not stated before me that while he went to the veranda of the accused, he found 4 persons running away from
So
the
this whole theory of 4 persons is introduced for the first time to the court.
in the court. And then again says it is a fact that he has stated before me that accused asked his wife to bring money from her parents for construction of well and latrine, and that no light was lit in the house when he went there, and that he switched on the light in the kitchen room and found the deceased lying unconscious with bleeding injuries on a cot.
Right. So a whole new story is introduced by PW8.
Yes.
All right.
And rest part of that hostile witness is admissible.
All right.
The first paragraph is admissible. Is admitting.
My humble submission before your lordship is, my lord, that now your lordship finds that a statement made in the court on oath, my lord, by a witness, and the police said he has not made such statement before me, and he was declared hostile. My humble submission before your lordship is, my lord, whether the statement given in the court on oath has to be given weightage, or the statement.
No. The question is, can this kind of a witness be trusted? That's all.
My lord, the statement.
Whether this witness can be trusted at all is a question. So you have to keep aside this witness.
And my lord, your lordship may kindly see the statement made in the court on oath and the statement made in the 161.
So the thing is, it points to the untrustworthiness of this witness. He can't be relied upon.
But 161 statement cannot be, my lord.
No, of course not, sir. 161 is only showing how untruthful this witness is. That's all.
But my respect to submission, my lord, on the basis of 161 statement, court cannot act upon, my lord.
Sir, nobody can act on 161. 161 is only used for confrontation, sir. That law is well settled.
So my respect to submission before lordship is, my lord, that this witness who was very much present, merely because, my lord, the police said, or he has not, he said, my lord, your lordship may kindly see paragraph, the first cross examination. I have been examined by the IO, as 90, my lord. I have been examined by the IO. It is not a fact that I have not stated before the IO that while I went to the pinda of the house, the accused and 4 persons ran away. He said that I have stated this in.
So you have the 161, you know whether he stated or not. If you say the IO is saying, come to page 134, this is what the IO is saying on oath.
I have seen that.
Page para 28 is also the IO stating on oath.
Yes, my.
You are the lawyer for the defense.
Yes, my lord.
Have you prepared this case without seeing the 161?
161.
Of course you would have not. Of course you would have seen the 161.
It's not available, my lord, because
I'm sure you have seen the 161.
No, my lord, it is not available.
Please.
In the paperwork, it is not.
Please don't. If you're going to attack the IO saying the IO is speaking falsehood, you have to show the 161 and show us that the IO is not speaking truth. When the IO is seeing the 161 and tells the court on oath that this witness never told me about 4 persons running away. If you want to say that the IO was speaking falsehood, you should show from the 161, see the statement in 161, he has talked about 4 people running away.
I never say, my lord, that he has that such a statement is available in the 161.
Sir, there are 2 statements on oath, correct? One by PW8 who says 4 people ran away.
My lord.
And further he says, I did tell when he's asked that you never told the police about 4 people running away, he denies it.
Yes.
So there is one statement on oath by PW8 who denies that he did not tell the IO about 4 people running away. On the other hand, you have a statement of the IO on oath who looks into the case diary and tells the court that he never made this statement about 4 people running away.
Yes.
You want us as a court to believe PW8 and disbelieve the IO, correct?
Yes, ma'am.
So how will you do it, sir? Only by showing the 161 before us and saying, this IO is speaking falsehood. Look, this witness did tell the IO that 4 people ran away.
No, my respect to submission before lordship is, my lord, the IO's statement, IO made a statement that he has not stated, so it must not be available in 161 statement, my lord. The IO, when Mr. Khatike has already read, that the IO has no, it is already the IO has stated in the court, my lord, in his deposition, that this witness has not stated before me that 4 persons were running away. So there is no question of checking, my lord, the 161 statement, because your lordship has to accept the IO. The witness.
Okay, you also say that we should accept the IO, correct?
Your lordship now between IO and this witness, my lord. Your lordship may kindly.
You are tying yourself in knots anyway. You are tying yourself in knots.
Your lordship, your lordship, my lord, between the statement in the court. Your lordship, I want to distinguish. Your lordship may kindly hear me. I don't mean that IO should be accepted. I do not want that outright your lordship should reject. Your lordship may give a patient hearing, my lord. It's a case under section 302, life imprisonment, my lord. My respect to submission, my lord. IO once has stated that he has not made such a statement before me. There is no need of going to 161 statement, my lord, the statement and to check up. IO must have stated, my lord. And my respect to submission, my lord, when the witness has stated in the court that I have stated.
So the question is, can this witness be trusted at all? The answer is no. That's it. That's the end of the matter.
Well, for appreciation of evidence, my lord, looking to.
Yes, sir.
My only point before your lordship is, my lord, that your lordship will kindly give a serious thought, my lord, that a witness who has stated in the court, IO said that he has not stated before me, whether he should be outrightly ignored or not, that I leave it here, my lord, for your lordship decision. Then, my lord, your lordship said that coming on the circumstantial evidence, even if accepting that this witness is a liar, this witness has not seen anything. Then, my lord, admittedly there is no other eyewitness. Then, my lord, coming to the circumstances available against me, my lord.
The first and foremost, 106 Evidence Act, dead body is found in your house. It's a homicidal death, correct?
Yes, ma'am.
It is a homicidal death?
Yes.
Dead body is found in your house, correct?
Yes.
So the explanation is to be given by you, sir.
Yes, my lord. My explanation is, my lord. My explanation is, my lord, that I was.
Let us see in your 313 what you say.
My lord, my 3-1 statement, my lord, I have read, my lord. I'm explaining, my lord. My explanation is, my lord, I am working as a piano. I was working as a piano at that time in a nearby high school, my lord. And on the date of occurrence in the evening, my lord, I had been to that.
Just turn to page 99. Question 40. Oh, no, that's right. Question 40 is, do you have anything else to say? It's all in Orissa. Just tell us what it is. 40. So this is in Orissa. So can you tell us what it is? Question 40, page 99.
I'm 99, my lord. 99. 99, there is no Odia.
With whom? Oh.
Page 99, there is no Odia statement. Page 99 of the paper, there is no Odia statement, my lord. Page 99 is the position of PW12.
You show in the paper.
Page 99. That is, my lord, this page 65 it is mentioned, my lord. Page 65. That tallies with my paper was not 99.
Even when they say the dead body was found. Even when it says the adjacent room where you're hiding with your sons, he says, I don't know.
My lord, your lordship, the last, have you anything to say? He said that Trupti Ranjan Das and Trupti Ranjan Das, my lord, the informant, and that he had a land dispute with his father. Trupti Ranjan Das, my lord, was lost the affair, except that witness others have not supported. Therefore, he said, Trupti Ranjan Das had land dispute with my father, and on 7/7/97, at about 9 p.m., I was at the school.
What did he say?
When I was returning, police
94,
arrested me.
page 94.
Because his defense is, my lord, that at the time of incident, at the time while police came to my house, I was very much present in the school. And while I was...
No. Question 8. 313.
My lord. Page 65, my lord.
Page 94.
Your Lordship, may kindly answer question number.
Yes. Next question. Question 9. False. So PW8 is not sleeping. Then question 10. 11.
No idea.
What does he mean? Sir, 90 page come to 95.
Yes. Yes, my lord.
Question 10. And question 11.
My lord, question 10, it further transfers from the evidence of Trupti Ranjana Das, PW1, who is the informant, my lord, that at about 10:30 p.m. in the same night, Bhubaneswara PW8 raised alarm and came out of the house, ran to the street, shouting all the times, what do you say? He said it is false.
Then come to the next one.
11, my lord. It further transfers from the evidence that on hearing the alarm raised by Bhubaneswar PW8, he went to your house and found your wife, Sanju, lying dead in a pool of blood on a cot in the entrance room from the kitchen, and her body was wrapped by a bed sheet. What do you say? I do not know.
He doesn't know.
He said.
So what is his case? Where was he?
Pardon?
You can hear me, no?
Your Lordship,
Where the appellant was at the relevant point of time.
Pardon?
Considering the reply of the appellant.
Sir, you're not able to hear us at all. Every time we ask a question, you keep saying pardon. You're not able to hear us.
Yes, ma'am. It's not audible properly, Your Lordship.
Now you're able to hear.
Yes.
Okay, now you ask the question.
You were in the house at the relevant point of time. Dead body was found in the house. What was the explanation offered by the appellant?
The explanation offered by me is, my lord, that he was not present in the house. He was present. He was a piano. He was present in the school. The headmaster of that school, my lord, has been examined as DW1, and DW2, my lord, is also another witness who says, a local witness who says that when the police reached at the spot, and accompanied me, asked me, the second witness said, asked me where I was serving. Then I said, the witness said, my lord, that he was serving in a nearby school. Thereafter, he accompanied the police to that school, and on the way, my lord, he was arrested. Your Lordship may kindly see DW1. DW1 is the headmaster of the school. Your Lordship may kindly see the statement, and not only he has deposed in my favor, my lord, he has also given some, my lord, he has also exhibited certain documents which indicates.
Let's read that.
Yes, my lord. DW1, your Lordship may kindly see. This is my defense, my lord. DW1 is at page 142.
We have it. Start reading it, sir.
My defense in the 313 statement is, my lord, supported by these three defense witness, my lord. One of them is a headmaster, my lord, a responsible man, my lord, who is the headmaster of the school. He has deposed and also annexed certain, I was exhibited certain documents, my lord, which would indicate that I was very much present in the school, my lord, at page 142. And his name is, my lord, Pavitra, that's something like that, my lord, at page 142 I'm placing. This accused was working as a peon in Jamandipur High School from in the year 1983. I joined as an assistant teacher in Jamade School, High School in the year 1985 and became its headmaster in the year 1988. The staff meeting of the school was held at 6 p.m. on 7/7/97. The meeting continued till 9 p.m. The staff of the school was noticed to remain present in the meeting. Notice number 7, dated 2/7/97, have been entered in the notice book. Exhibit A is important. Exhibit A is the relevant entry in the notice book. Exhibit A by 1 is the signature of the accused. Resolution dated 7/7/90 relating to the meeting number 7 was passed in the meeting, and Exhibit B is the relevant resolution. The accused was present in the meeting. This is my defense. The accused was present in the meeting. The accused has signed the resolution book by the Exhibit B by 1. This has not been found to be forced or false document. The meeting was followed by a dinner. I left the school at 9:45 p.m. The accused was present in the school till then. So my respectful submission before
Please read the whole evidence.
Yes. The cross-examination, my lord. The house of the accused is situated at a distance of 3 kilometers from the school. Accused comes to the school by riding a bicycle. It takes 20 minutes to reach the school from his house by cycle.
So he is either walking very slowly with the cycle, he's pushing the cycle and walking along with it, sir.
It has
3 kilometers, it takes 20 minutes by cycle.
It has to be matched with the time when when the police reached. By the time when the police reached.
So you have to calculate whether the cycle goes 3 kilometers or not. You have to find out how much the police is saying, and accordingly you have to say 20 minutes.
Not
so 3 kilometers going by cycle takes 20 minutes.
This is
Anyway. All right. Carry on.
What in 9:45 he was present, my lord?
No. Please read on, sir.
I do not know Achyutananda Mahanti. I do not know Nilu either. The resolution does not reveal that the meeting was dissolved. The school was a private institution till 1993. Now it has taken over by the government. The notice book, resolution book produced today.
Yeah, that's what I'm saying. 3 kilometers away next door.
Have not been verified by the DI of the schools or any other person, officers of the education department. I have opened the resolution book and notice book at my initiative. It is not a fact that I have created these books in order to screen the accused of the offences.
Actually.
Then your lordship may kindly see.
The next defense witness, let's see.
I know the accused in the dock. I belong to the village of the accused. On 7/7/97 evening, I was present in my house in village Gopinathpur at 9:30 p.m. while I was sitting in my veranda. Devendra Patnaik, the husband of the sister of the accused, informed me that wife of the accused was murdered. He informed me that accused had gone to Jamade High School. I advised him to inform the police over phone and for the accused. Half an hour thereafter, police came and to our village. The police asked me to show where the accused serves, and I went with them to show. By that time, he was already murdered, my lord. So, the school. I showed them the school. The accused was present in the school at that time. The police took the accused from the school to the PS. The PW1 was civil. The PW1 has civil dispute with the accused. I have not given any statement before the police. PW8 cross-section. PW8 is a nephew, son of the accused. I do not visit the house of the accused. Accused is my cousin, also known as Banna. It is not a fact that the police had not sought for any help for finding out the school, and that I took the police to the school, and that the accused was present in the school, and that the police took the accused from the school to the PS. the house of the accused consists of two rooms. The front room is used for the cooking and the other room is used for the for bedrooms. It is not a fact that on hearing alarm of 8 PW8 that the deceased was lying in a pool of blood in the house. I went to the house of the accused and that I found the dead body of the deceased in the front room and that the accused was concealing himself in the bedroom, closing the door from inside. It is not a fact that I am deposing falsehood.
Yes. The next witness is very interesting. So you produced another witness who's involved in dacoity. DW3.
Yes, ma'am.
Neelu Bhoi.
PW3 stated, my lord, that
DW3, sir.
DW3, my lord, I know the accused in the dock. I had been to the Lingaraj PS at 12 noon on 8/7/97. I stayed there till 11 p.m. Again says I stayed there throughout the night in the PS. The police detained me on my younger brother in the night in the PS. The police seized wearing apparels of the accused. Accused had worn a trouser and a shirt. I have not signed the seizure list. The accused had not put on dhoti because a dhoti was seized.
Why did you produce this witness?
Because a dhoti was seized, my lord, which contains stains of blood, and for which probably the defense has examined this witness to indicate that, to prove that, to disprove that he was not wearing a dhoti on the right, he was wearing a trouser. Probably that is the reason for which the defense lawyer has examined this witness as DW3.
And look what this witness turned out to be.
And your lordship knows, my lord, that when there are evidence of a prosecution witness and defense witness, my lord, merely because some witness is a prosecution witness would not be given any higher weightage, my lord, because the defense witness
No,
also.
we are only reading defense witness, and I can tell you it's very interesting, this DW3. DW3 cross-examination, if you read, you'll find some very interesting
I had
details.
quarreled with my brother, Kannu Bhoi. It is not a fact that I had been to the PS at 10:30 p.m. to complain against my brother, Kannu Bhoi. It is not a fact that I came back from PS after lodging the affair. Again says I made a station diary entry. I am an accused in 3 to 4 Dokaiti case. A criminal case was also instituted against me at Khorda court. It is not a fact that I have not seen the accused in PS wearing a trouser and a shirt. It is not a fact that I have not witnessed the seizure of the wearing apparels of the accused. It is not a fact that I am deposing falsehood being gained over by the accused. It is not a fact that I had not stayed at the PS from 12.
So you want the court to rely on a witness like this?
Why not, my lord?
I see. All right. You can argue anything, sir. That's your privilege.
Because my lord,
you should argue anything that you like.
Because your lordship is.
I've never heard a counsel say, "Why not?" like this, as if
Because
you should actually be arguing to persuade the court. What you're saying is, I will tell you something, you have to believe it.
That is not my.
That's your attitude.
No, that is not.
What kind? The answer is, what kind of a question you're asking? Of course, you should believe.
Yes, no, I'm sorry, ma'am. If that is.
We are asking you a serious doubt, sir.
I didn't mean that.
You should give us some credence. This is not the first criminal appeal you are hearing.
Yes, ma'am.
When we read a witness, a doubt comes to our mind.
Yes.
We're asking you, should we rely on a witness like this? And you're saying, why not?
My most humble and.
I have never seen arguments like this.
I'm sorry, ma'am.
You should, a good lawyer,
I have also
a good lawyer will understand that the judge has some doubt in his mind, you should clarify that doubt.
I am a lawyer here, my lord, since the last 44 years, and
which is why I thought we could ask you these questions.
And I have
never anticipated we'll get a reply like this.
And I have argued matter before lordship while your lordship.
You never anticipated we'll get a reply like this.
I have argued matters before lordship while your lordship was at.
When a judge is asking, sir, you may have been a lawyer of 44 years. When a judge is putting a doubt in the judge's mind,
I have to stick, my lord.
You should clarify the doubt,
Yes,
not say what kind of a doubt you have.
My clarification, why will this witness will not be believed, my lord. My respect to submission, your lordship is probably prejudiced because he is involved in 2 to 3 docket cases, my lord. So my humble submission before lordship, merely because he is involved in 2 to 3 docket cases, my lord, his presence at this police station is born natural. If he is an accused in a docket case, my lord, so he must have been called for that. So my humble submission, why not this witness will be disbelieved, will not be believed, my lord. That is why I use the word why not, my lord. That doesn't mean, my lord, that I want to justify, my lord. Your lordship wanted to justify. Your lordship simple question to me is, my lord, you want to believe this.
It only shows, since you have 44 years practiced in this bar.
44, my lord. 44 years.
No judge should ask you a question. That is what you are saying.
No.
Yes.
No.
You are saying, I have practiced 44 years. Don't ask me questions.
If in that way, my lord, I need not argue this matter.
It's okay. It's every day is a humbling experience, sir. A lawyer of 44 years tells the judge, please don't ask questions. We will abide by that. You are such a senior lawyer. You have to argue the way you like to argue.
No, my lord.
Yes. We should not tell you how to argue, correct?
No, criminal appeals, we are arguing for hours together, my lord.
Correct, sir.
And for
correct, sir.
Even for
so judges are not supposed to ask questions. Basically, that is what you are asking. You are saying, if I have practiced 44 years in the bar, don't ask me questions.
No. Why you are lordship interpreting in this way? I don't understand. This is not my intention, my lordship knows, my lord. This is not my intention, my lord. And your lordship, why your lordship asking me question now? How can I say? How can I? I'm a practitioner of 44 years. I will ask that to you. Why your lordship asking me question? That is not my intention, my lord.
All right.
I said, why not you will be believed? That doesn't mean when I want to justify why you will not be believed. Your lordship may give me an opportunity. That doesn't mean that I am your lordship asking me a question. I said, why not? This why not? Your lordship may kindly give me opportunity that why not this witness will be believed. I'm standing for the accused, my lord. Your lordship asked me a question. Do you want PW4 under these circumstances, PW4 should be believed? I said, why not? So this why not, your lordship may not accept and say disrespect or any argument, nothing, my lord. To justify that this witness should be believed. That is my intention, my lord. So your lordship, I may not be misunderstood, my lord, in that view.
Carry on, sir. Carry on.
Lordship's mind is closed. My humble submission, my lord, for lordship, my lord, 302, my lord. That is absolutely true. No evidence, my lord.
No, you have to go through the judgment of the trial court. Tell us why the judge went wrong. In an appeal, sir, criminal appeal, again, if you say, no, I've got 44 years experience, don't tell me, then we'll stop.
And only in criminal.
I only expected in a criminal appeal, somebody will say why the trial judge went wrong.
Yes. Trial judgment, my lord, and I have been practicing only in criminal side. Again, I say, my lord, the trial judgment is, my lord, the conviction is based on, I have already stated, either on circumstance evidence or on eyewitnesses, my lord. Therefore, at the my outset, I was trying to present with your lordship that there is an eyewitness, but he has not been believed. Your lordship found that he's a liar, or Mr. State Counsel said that he has not stated so for the IO. So it is for your lordship, it is for the honorable court to decide whether he should be accepted, he should not be accepted. Coming to the judgment, as your lordship said, in the judgment matter, he has convicted me under section 302 and 304B. So for 302 is concerned, even if my lord 302 is concerned, my lord, the specific case, the prosecution case is, my lord, that the prosecution case is, my lord, the prosecution case is, my lord, that he was present, his wife was found dead. I have proved the case, I have tried to disprove the case that he was not present, he was in the school. Then, my lord, coming to other circumstances, my lord, that other circumstances, my lord, that he was very much, the conduct shows, my lord, he was very much, rather, your lordship, that he was very much present, even if coming in the other way, my lord. If he is the killer, if he has killed his wife in the house, police was coming, it was already disclosed, he would have ran away, my lord. He would have concealed, he would have absconded. So he was very much present there, my lord. He has never tried to abscond, my lord. So, my lord, that is the conduct of the accused. My lord, even if we accept it. Then, my lord, lordship may kindly see, I am placing the judgment, my lord. The accused stands, well, the whole judgment, your lordship may not have patience to. So far 302 is concerned, my lord, that the case has not been proved because the circumstances, as your lordship know, in the case of Sarath Viranchi, my lord, the circumstances, chain of circumstances should be so complete, my lord, and there should not be any missing link, my lord. That being the principles, my lord, while applying the principle of circumstantial evidence, my lord, my humble submission before lordship is that the circumstances, that is admittedly there is no eyewitness, and if there is no eyewitness, my lord, the circumstances presented by
Yes, sir.
Coming to PW1, my lord, with the on the basis of whose, my lord, the conviction is best, I'm placing the statement of PW1, my lord. I know PW1 is the only witness. I know the accused was standing in the dock. I also knew his wife, who is dead since 1997. She died on 7th June 1997. The accused and his wife were my next door neighbor at Gopinathpur. The accused was staying there along with his wife and two small sons. The accused married the deceased in 1993. The sister of the accused was staying in that locality with her husband and two children. At the time, the children of the sister of the accused used to come to the house in the night to sleep. On 7th June 1997 night, I was sitting on my cot after witnessing the TV serial Om Namah Shivaya. It was at about 10:30 p.m. when I heard this house of the nephew of the accused called Bhubaneswar Patnaik. I came to out of that house and saw Bhubaneswar running from the inside the house of the accused to the Danda side, shouting all the way. Hearing his shouts, 5 to 6 persons also came and entering inside the house of the accused. They were Achyutananda Mahanti. These witnesses might not examined. They are Achyutananda Mahanti, Abhirama Parida, Ishwar Kumar Kanungo, Hudananda Mahanti, and Deepak Das. I also entered inside the house of accused along with them. The house of the accused consists of 2 rooms. In the first room, the nephew of the accused used to sleep. This nephew of the accused, my lord, is the other witness to whom I am claiming that he is an eyewitness, my lord, PW8. And these witnesses who have been referred by him, my lord, 5 to 6 persons also came to enter inside the house of the accused. They are Achyutananda. These witnesses have not been examined, my lord. If they are also equally important and material witnesses, my lord, they have not been examined. In the first room, the wife of the accused was lying on the cot of sleeping posture, and the chadar was covered on her body, and there was blood on the floor of the room. Those persons named above, seeing the blood, told that he was dead. She was dead. Then we all came to the house of the and went. We called Devendra Patnaik, the sister's husband of accused, and asked him to telephone the matter to the police station. At about 12:30 a.m. Or 1 a.m. in the said night, police came to the accused. I orally lodged the affair before the police in the same night. Police reduced my informations into writing, and knowing the contents of the signed, this is the affair. Exhibit 1 is this is my signature of exhibit 1 by 1. The police in my presence seized the chadar which was covered on the dead body. One iron rod, only blood-stained earth collected from the floor of the room, one plastic bag, one mat, and prepared the seizure list. Exhibit 2 read over the contents to me, and thereafter I signed. This is my signature, so and so. On the next morning, the police came again, told at about 9:30 a.m. Magistrate also came. Some statements were recorded, and thereafter police held inquest over the dead body. Prepared the inquest report, took my signature. This is the inquest report, exhibit 3. This is my signature, exhibit 3 by 1, 3 by 2. There was mark of injury on the cheek, head, and lips of the deceased. Photographs were also taken. I have signed at the spot also. I was called to the police station where also I signed on some papers. I cannot say specifically on which papers I signed the police stations, on which paper I signed at the spot. When I came out of my house, hearing this sound, soon after the above mentioned persons were coming from the Danda side, they and myself stood at the door and not stepped inside the room of the house where the dead body was lying. The articles which were seized in my presence under Annex 2 were not seized at the police station. At that time, many persons, including me, were present on the danda of the house of the accused. Police showed us the seized articles at the danda where we stood. Bhubaneswara, after shouting, went to the house through the danda, in the night, police arrived at the spot. It came to the spot, being called. The contents of the affair, this is important, mind on. The contents of the affair were not read over by the police to me. There is a common passage used by the accused's family and my family. There is no demarcating fence in between my house and the house of the accused. It is not a fact that we had a dispute over the common passage, and that I am deposing falsehood against the accused. And he has never stated, my lord, this witness, who is a most important witness and who has stated on the basis of whose statement, my lord, this conviction lies, he has never said that he was present or he has seen anything, the accused was running away or the accused was there. He never said, my lord, except said that he was concealed. And my lord, one of the important factors, my lord, Orissa may kindly see, he has never said that the affair was also not read over and explained to him. That also he has said the affair was not read over to me, my lord. So, and my lord, except this, my lord, other witnesses, my lord, he said that other witnesses were present. None of them have been examined, and none of them have stated also that he was also present, my lord. So, except that witness, my lord, there is no other witness, my lord, to speak about my presence at the house, my lord. And my lord, your lordship has seen the defense witness subject to correction, my lord, even if the other defense witness, your lordship said, the Dokaiti case, somebody involves, even if your lordship will not accept him, the other teacher and headmaster and other witnesses, my lord, that indicates that he was very much present in that school, my lord. And your lordship knows, my lord, that the prosecution evidence and the prosecution evidence and the defense evidence, my lord, should be given the same weightage. Merely because some witness is examined for the defense, his evidence should not be ignored, giving preference to the prosecution evidence, my lord. That is the settled principles of law. Then, as your lordship was asking me, my lord, to go to the judgment, if your lordship will permit me kindly, I will place the judgment also.
Yes.
My lord, whether I will place the whole judgment or your lordship. And conviction is under section 302 and 304B. So for 302 is concerned, my lord, this is the material, my lord. I have placed and your lordship has also seen. And so for the defense is concerned, that he was not right. Admittedly, there is no eyewitness. And to whom I am claiming or defense is claiming an eyewitness, my lord, that since he was not examined by the police, my lord, it is for your lordship whether merely because he has not stated that statement before the police, whether he will be accepted or not, that is for your lordship to decide. This is regarding 302, my lord. So for 304B is concerned, my lord, absolutely no case is made out. In that case, my lord, I will place the judgment. So for 304B is concerned, my lord, the crux is, my lord, that there must be a demand for dowry. The death must be within 7 years of the marriage. Number 2, my lord, there must be a demand for dowry in connection. There must be a demand for dowry. There must be a torture money in demand of dowry. And the death should be an unnatural death, my lord.
Yes.
So if your lordship will permit me, can you place the judgment, my lord?
Yes, yes.
The accused stands charged under section 4 of the
Not from there, sir. I can start from para 12. Let's first focus on 302. We'll go to 304B later.
Yes, ma'am.
Let's go to 302 itself. Para 12.
Yes, ma'am. Now, coming to the charge under section 302 IPC, I find that the informant widow 1, a closed door neighbors of the accused, has testified that the accused was staying at the next door with his wife and 2 minor sons. The sister of the accused has married to Devendra Patnaik of the village Gopinathpur, and at the time, PW8, the son of the sister of the accused used to sleep in the house. PW8, my lord, your lordship, that witness, my lord, to whom your lordship of the accused in the night of 7/7/97 at about 10:30 p.m. while watching TV serial, he, PW1, heard the shouts of PW8. He came out of the house and found PW8 running away from the house of the accused. He, along with other villagers, went to the house of the accused and found the dead body of the deceased lying on a cot in the entrance room, first room, and a chadar was covered over the dead body. There was pool of blood on the floor of the room. He, along with other co-villagers, called the father of PW8 and asked him to inform that the police over phone. The police came in the night on getting the telephone message and took the accused to their custody. He, PW1, orally reported the occurrence to the police. When the police reduced into writing by the Annex 1, by the Exhibit 1, whether he lent his signature there on the Exhibit 1 or not after knowing it is contents. The evidence of the IIC, Lingaraj Police Station, PW19, is that on 11:50 p.m. in the night on 7/7/97, Sri K.N. Das of Gopinath Police of Capital Police Station informed SI S.K. Mahapatra of Lingaraj Police Station that a murder has been committed in village Gopinathpur, wherein the ASI Purnachandra Sahu, PW18 of Lingaraj Police Station, made the station diary entry 147 and he PW 19 along with PW 18 SI LD Mahapatra and 2 constables proceeded to village Gopinathpur by jeep and arrived there at 0:30 a.m. They found the gathering in front of the house of the accused, and some of those people informed them that the dead body of the accused was lying in the house of the accused, was hiding in the adjacent room and was not responding to their calls. He, PW 19, along with his team of police officers and PW 1 and other villagers entered into the house of the accused, which consists of 2 rooms and found the dead body of the deceased lying in a pool of blood in the entrance room, which was also used as kitchen, and the face of the deceased was covered with the printed bed sheet and her legs were hanging over the cot. A blood-stained iron rod was resting on the wall near the cot, and a blood-stained vegetable cutter was lying on the cot beneath the cot of the blood was dripping from the cot to the floor. On removing the bed sheet from the face of the deceased, he found injuries on her forehead, nose, cheek, chin, and her hair was doused with blood. The accused was hiding inside the adjacent room along with his 2 minor sons by bolting the door from inside and came out with his minor sons in response to the call of PW 19. As the accused enraged emerged out of the room, the IO PW 19 found the dhoti he was wearing was stained with blood and kept the accused under his surveillance and gave the minor son in the custody of Devendra Patnaik, the father of the PW 8. The PW 1 orally reported the occurrence to him, and as per his directions, PW 18 reduced it into writing, read over and explained the contents thereof him, whereafter PW 1 put his signature. He treated the informant, lost this affair by PW 1, had Exhibit 1 affair, and took the investigation. The IO PW 19 inspected the room of occurrence thoroughly, and as per his direction, PW 18 prepared the spot map Exhibit 16. On the requisition of the scientific officer with his team arrived at about 9:15 a.m. on 8/7/97. The scientific officer collected the blood-stained earth MOX and sample earth MOXI from the floor of the room of occurrence and made material objects over him. PW 19. He seized the blood-stained iron rod, PW MO2, and the vegetables cutter MO3, blood-stained mat spread over this cot MO1, blood-stained polythene bag MO6, hung to the wall from the room of occurrence, and also the blood-stained earth and the sample earth collected from the floor of his room by scientific officers in the presence of PW 1, 4, and 6, who have attested the seizure list Exhibit 2, which was prepared by PW 18. PW 19 held inquest over the dead body of PW 14 and PW 7, during which he found several injuries, including 2 depressed injuries over the dead body of the persons. And the injury is not disputed, very much disputed matter. PW 18 prepared the inquest over Exhibit 3, which has been attested by the executive magistrate, PW 14 and PW 7. He issued command certificate and a dead body challan through the constable, namely constable number so and so, name so and so, Sugriva Biswara, commanding them to carry the dead body of the deceased to the capital hospital, Bhubaneswar, for post-mortem examination, and P 7 also accompanied them. He also sent the blood-stained iron P 2 and a vegetable cutter MO3 through the constables for opinion of the doctor. He brought the accused to the Lingaraj police station, and there at 11:30 p.m. on 8/7/97, the IO P 19 seized the blood-stained dhoti MO5. He had worn the presence of P 18 and the SI Anand Chandra Sahu under the seizure list. Exhibit 17. My lord, here for a moment, my lord, if a lordship asking me that there's a DW3, my lord, he has deposed on this point that he was not wearing a lungi, he was wearing a trouser. Whether accepting that or not, that your lordship, your lordship will please, that's appreciation evidence for your lordship. And I said, and in that case, again, I say, man, I may not misunderstood that. I said, why not this witness will be believed, my lord. Again, I'm sorry.
Come to this, the para 21.
My lord.
The circumstances have been set out, sir. After the judgment is quoted, page 37.
Yes.
In the present case, the following incriminating circumstances have been proved.
In the present case, the following incriminating circumstances have been proved against the accused. These are my lord, the circumstances. Number one, the accused was pestering the deceased to bring a sum of rupees 10,000 from the parents' house. That I will go to the respective evidence and to show that how it is not proved. He was in the company of the deceased inside his own house in the night of occurrence. This, my lord, I dispute because nobody has stated clearly that he was present at the time of murder. He was present at the time of murder. Suppose after coming back from the school, my lord, if he was present and recovered by the police, that has been explained that while coming to the school, he was taken by the police. So my humble submission, my lord, therefore, my lord, at the initial stage, at the beginning, my lord, I was trying to impress your lordship that eyewitness is very much present. Of course, that is subject to your lordship's acceptance. PW8 was present. He said 4 persons assaulted. Forgetting that 4 persons theory, my lord, forgetting for a moment for that 4 persons theory, my lord, even if he is a witness man, he would have said that this accused was trying to run away. The accused was present in that room. There is nothing to show, my lord, even so far the circumstances, evidence is concerned, there is nothing to show that both of them were together. My lord, your lordship knows, my lord, suppose the wife and husband, they were in one room, and in the morning the wife was found dead, then the husband will be automatically responsible because that would have been a strong circumstances. Here there is nothing to show, my lord, that they were sleeping in the same room. Nobody has said so. My lord, and my lord, even P 1 has not seen them together, my lord. So, my lord, at best, if your lordship accept the police statement, police versions, and the statement of the PW1, my lord, that he was recovered from the room with his 2 children. My humble submission before lordship, your lordship may kindly visualize a moment, my lord, where the wife of the deceased, wife of the accused, is murdered by some unknown accused persons, and being panicked, he was very much present with the 2 minor children. And again, my humble submission before lordship is, my lord, somebody who is committing a crime, ghastly crime, my lord, committing the murder of his wife, will definitely try to abscond, to leave that place, to avoid police apprehension. He will definitely, and that is the human psychology, my lord. That is the mind of, that is the human psychology, my lord. Anybody committing such a crime will not remain present in that house till police come and recover him from the neighboring house. So my humble submission before lordship is, my lord, so even accepting that he was present in that house, but there is nothing to show that they were sleeping in the same house, nothing to show that she was found to have been assaulted by her husband, by any witness, even PW1, rather the witness to whom, whether he will be believed or not, that your lordship will decide. The other witness, PW8, he says that 4 other persons have assaulted. You will forgetting that 4 other persons theory, my lord. So far his role is concerned, there is no eyewitness, number one, there is no eyewitness who had seen them together at least in that night. That wife and husband were together for a moment, for 5 minutes, for nothing, my lord. So there cannot be a presumption, my lord, that merely because I am the husband and merely because I was present in the other house, even if my wife is murdered by some culprits, my lord, I will be automatically responsible. That is not the law, my lord. In that way, my lord, no presumption can be raised against the accused that I, being the husband, I will be automatically responsible for the wife of my murder, even if she was murdered by some other persons. And my conduct is, I have not tried to run away. I have not tried to fly away from the spot. I have not tried to escape, my lord. Not that while the police came and I was trying to run or the police caught me, nothing like that. So, my lord, nothing to show that I was trying to escape. And so many independent, as per the evidence of PW1, my lord, so many other witnesses, it happened in the village. And so at the early hour of the night, it is only at 9:30 to 10 o'clock, my lord. So many persons would have been gathered there. Nobody has also stated regarding my presence or regarding my presence in that room. That is the state of affairs so far 302 is concerned. And no other witness has stated regarding my involvement in committing the murder of my wife. And again, I pray your lordship, again, I humbly submit your lordships that looking to the defense witness, whether accepting or not, that is your lordship's prerogative, my lord. But your lordship will kindly consider comparing the statement of the defense witness, the headmaster, who is a very respectable witness, headmaster of a government school, vis-a-vis, my lord, this witness, my lord, who even has said that the affair was not read over and explained to me. I leave it to lordship to appreciate and decide that.
Yes, Mr. Gatkar.
And 304 is B is minded there. 304B is there. 304B is there. So
Yes.
So your lordship will permit me.
Yes.
So for 304B is concerned, my lord, your lordship know, my lord, that there are 3 conditions, my lord, that death must be within 7 years. Death must be an unnatural death. And soon before death, she should have been subjected to torture on account of a demand of dowry. These are the 3 criteria to attract the application of section 304B of the Indian Penal Code, my lord. And so for this case is concerned, your lordship will find that marriage is within 7 years, it is not disputed, my lord. That soon before her death, she was subjected on account of a demand of dowry. There is absolutely no material, my lord, because my lord, because his own, the interesting, my lord, her own brother has been examined, 2 sisters, my lord, 2 married sisters who are married since long. They have stated that he was demanding for 10,000 rupees for construction of a latrine and for the education of the children, having nothing to do with the dowry. He was asking for her husband, for his father-in-law, from his father-in-law's house, for demanding for construction of a latrine, 8,000 rupees, my lord, and for the education of his children. That is the statement regarding demand, and which has been denied by his own brother, who has been examined. The lordship will find PW7 at page 82.
PW7 turned hostile, sir. PW7 turned hostile. You come to para 11. Para 11 of the trial court judgment, page 107. 107 or 25, I don't know. 2 pages. 25, sir, page 25, para 11.
So far as demand of sum of rupees 10,000 by the accused few days before the death of the deceased, it is concerned. Widow 13 has admitted during cross-examination that she has not stated this fact to the IO during her examination under section 161 CPC, and as such, this is a contradictions in the evidence within the mischief of section 145 of the Evidence Act. But the PW 15 has stated that the deceased told her that the accused demanding a sum of rupees 10,000 for constructing a latrine, digging well, and giving education to the sister's son was torturing her as the amount was not paid. In the absence of any infirmity, I do not find any reason and discard her evidence and hold that the accused was pestering the deceased to bring a sum of rupees 10,000 from her brother, for which he accused was torturing her with cruelty. The death of the deceased having taken place wherein then and normal circumstances within 7 days from the date was escorted back home, the accused. I hold that this would be for her death. She was subjected to cruelty and harassment by the accused husband in connection with the demand of dowry. That the charge under Section 4 of the Dowry Prohibition Act and Section 419-304B stands proved. So my respect to submission before Lordship is, my lord, that the one brother of the deceased has been examined as VW 7, my lord, at page 82. Your lordship says that he has been declared hostile, my lord. And I'll also cite a decision. So I'll try to cite some decisions. One is a hostile witness. The statement of the hostile witness should not be completely thrown out, my lord. The portions of the evidence which can be accepted by the court and can act upon, my lord.
Sir, if the trial court has relied on PW7, you should argue PW7. The trial court has not relied on PW7. The trial court has relied on PW15.
Trial court, your lordship, being the appellate court, my lord, I will urge all the points that the trial court, even if accepted the witnesses, my lord, and has not considered the statement of some other relevant witnesses, my lord, your lordship may also, my humble submission, my lordship may also consider that the brother, my lord, the question is, my lord, the married sister on whom the trial court has relied regarding torture of demand of dowry, and the brother who was a party to the marriage, the brother, my lord, your lordship may kindly see, the brother and the brother-in-law, they have not stated. The married sister, my lord, they have stated. So merely because, my lord, the trial court has not relied on them and has relied on the statement of the sisters. So your lordship may permit me to distinguish or to make a submissions that even if they have stated, even if the trial court has relied, merely because the trial court has relied, so my lord, therefore it is, since this is being the appellate court, my lord, your lordship will kindly consider.
All right. Yes, Mr. Katke.
May I please, your lordship? I'd like to draw your lordship's attention to page 111. That is the doctor, PM doctor, who has conducted the autopsy.
Yes.
The number of injuries, your lordship can appreciate from paragraph 2. I found following external injuries on the dead body. Then 1, 2, 3 loss. On a lacerated, then was 6 is fracture of left zygomo, left side of face and left eye were depressed, eyes were black. Then 7 fracture of both maxilla bones. Then 8 lacerated wound of into bone dip on the left side of chin, irregular lacerations on upper lip and adjoining cheek. Because these are the injuries. So wherefrom your lordship can have the impression the way the disease has been dealt with by her husband. And PW18, I would like to draw also the page 115. This paragraph 3 as page 116. A mat was spread over the cot, whereupon the dead body was lying on a pool of blood. Some of the people present there informed that the accused was hiding inside the adjacent room by bolting the door from inside. The IIC called the accused to come out of the room. The accused opened the door and came out with his two minor sons. Accused was wearing a dhoti which was stained with blood. And this dhoti was that is sent to the for chemical examination. And your lordship must have come across
B group blood.
Yes, that is page 152. The weapon of offense plus 1 iron rod has been used. That carries human B, blood of group human B. Then paniki, that is also a sharp cutting weapon. That is also that carries also the blood group of human B. Mat also that is a human B. And sari, saya, and blouse of the deceased. Those are sari, saya. all carries extensive human blood, but two sari and saya, that human being. And sample blood also human being. And bedsheet and dhoti of the accused, that carries human being. So the wearing apparel of the deceased was carrying the blood of the same group of that of the deceased loss. As clear
The accused had no injury on his person.
Pardon?
And the accused had no injury on his person.
No, accused need not have any.
I'm saying something, sir. When the accused has no injury and he's wearing a bloodstained dhoti, the blood must have been coming from somewhere else.
I'm sorry. My lord, my lord. And P2 15 is the witness. That is that is at page 105. He has been testified to prove the dowry demand. I am the elder sister of the deceased Sanju. The accused and dog is the husband of the deceased Sanju. The marriage between deceased Sanju and the accused took place on 12/3/1993 at Palla. At the time of marriage negotiation, Pramod Das, acting as a broker on behalf of groom side, demanded rupees 15,000 in cash and a TV. Pramod Patnaik, the husband of my elder sister, paid rupees 12,000 in cash to the accused in presence of Devanand, the brother-in-law of the accused. I came to my father's place to attend the marriage. I went back to my matrimonial home. I again visited my parents' place at Palla on 25th June 1997. Accused came to the house of my parents along with my sister Sanju and children on that day. My brother was blessed with a daughter. The accused, without taking food, left the place immediately. After torturing Sanju. After the departure of accused Sanju, Sanju told me that accused was demanding a sum of rupees 10,000 for constructing a latrine, digging a well, and giving education to his sister's son and torturing her as the amount was not paid. So I left for my matrimonial home on the next day. I received information that 6 days thereafter, the accused escorted back Sanju to his house. In the morning of 8/7/1997, I came to know that the accused assaulted Sanju to death. Then I was given in marriage 7 or 8 years before the marriage of Sanju. My maternal uncle and brother-in-law had arranged the marriage of Sanju. They looked after the marriage affairs. I have heard from my brother-in-law, Pramod Patnaik, that he paid rupees 12,000 to the accused in the presence of Devendra. He's saying in the cross-examination. It is not a fact that accused has not administered any threat to Sanju when he visited my parents' place at Palla. On 25th June 1997, Nilakanta Das presided over the marriage ceremony of Sanju with the accused and Sauri Barik afflicted as a barber. It is not a fact that I was not present on the occasion of the marriage of Sanju. So that is consistent regarding about the demand of dowry of 10,000 rupees and in the torture. And the other aspect was plea of alibi. Whatever has been introduced during the defense laws. The defense witnesses are being given when a plea of alibi, a plea is taken in the prosecution. Plus, no, your lordship will not find any plea of alibi in any of the cross-examination of the prosecution witnesses anywhere. Rather, while examining PW 8, they have introduced a plea that some other persons, 4 other persons have come and murdered the deceased inside the house. Here, the plea of alibi, and also in the 313 statement, you also find at page 65. Of course, in ODM loss, Madam Anuja Patnaik can understand. The accused has admitted more there but I didn't have any injuries. Then question number 40, Trupti Ranjan Das, PW1. because PW1 and his father were having some civil disputes. And on 7th July 97, at around 9 p.m., school gharaku asila bale police was dharla. When I was coming from the school to my house, police got hold of me. So this is the plea he has taken in his 313 statement. So no plea of alibi is available here. So taking no plea of alibi, he has led the defense to sustain a plea. So that is not the usual rule of criminal practice laws. And so far as FIR laws, you will also find FIR at page 44. There was the occurrence time is, that is on Monday, 7/7/97 at about 10:30 p.m. And information received at the PS on 8th July 97 at about 3:30 a.m. in the same night. And marriage is just in 1993, within 7 years of marriage, there is so there is no dispute over that. And regarding the other aspect, what my learned senior is saying regarding proximity of time, so as because soon before death, she must have been subject to cruelty. That part, that always cannot be said that yes, just before the occurrence, she must have been subject to cruelty, because she has been kept tortured right from the beginning for a demand of rupees 10,000 rupees. And so far as 302 is concerned, because it's consistent evidence of P.W. 17, the doctor who has been examined, and his evidence shows that also it's a case of homicide. And also the other evidence, chemical evidence report, that substantiate the post-mortem report. And what my learned senior has said, that there is no case of 302 plus, I don't understand how he's saying. And here, so far as 106, so far as law is concerned, Section 106 of the Evidence Act, when it is it's exclusive knowledge of the accused, he has to say what has happened here. And in that event, also, I can rely upon the judgment of the Honorable Supreme Court, that is 2006, volume 12 SEC. I'm sorry, I will supply the judgments also. 2006, volume 12 SEC 254. And the other one, the most important, that is 2006, volume 10 SEC 681, Trimukhi Maruti Kirtan. And in another case also, I had shown that judgment to your lordship.
Just the Maruti?
2006, volume 10 SEC, page 681, Trimukh Maruti Kirkan versus State of Maharashtra. And the earlier one is State of Rajasthan versus Kasiram. I'm only showing two judgments. Your lordship will get on 106 of the Evidence Act is concerned.
Correct.
And here PW 18 has also stated another aspect, that also I'm bringing to stand notice. Page 118. That goes on demolition clause. Paragraph 11. On 8th July 1997 at 11:45 p.m. at Lingaraj PS, the IIC seized the wearing apparel of the accused, the bloodstained dhoti in presence, and SI Arnadicharan Sahu. I scribed the seizure list as per the dictation of IIC. Exhibit 17 is the seizure list, and Exhibit 17/1 is my signature. So when dhoti carries blood, they came to know that dhoti is carrying blood. So DW3 has been introduced. A person having so much of criminal background, he has been introduced. So all the three witnesses who have been examined on behalf of the defense, they are not reliable. Because and plea of alibi, also your lordship has held in another judgment, plea of alibi is not available in this case, because that person is very well there in the village, near the school. And the time gap is very small. At best, it started from 9:45 to 10:30. I'm not going to that, because plea alibi means the person should not be physically present. That is Latin word that means he should not be physically present. That was even in the illustration, Section 11 of the Evidence Act, that say there is a illustration that a person, suppose he is in Lahore and a crime is committed at Kolkata. It is not possible at all. Any prudent man cannot just believe that that person can come from Lahore to Calcutta to the crime scene to commit the crime. In that case only, plea of alibi may be sustained. But here he was very well present. At best, if at all, PW 1 and 2 will be believed. And PW 1, 2, 3, they cannot be introduced as witness because there was no plea taken. No plea of alibi has been taken earlier. Rather, the plea advance was the 4 other persons have introduced into the house of the deceased and killed her, as PW 8 has stated. PW 8 has turned hostile. And if that, my learned senior was argued, that's part of the evidence of a hostile witness can be used. Plus, I am agreed. If that is so, that PW 8's, a substantial part of PW 8 will be admissible. Because he has admitted that the accused and his wife and 2 children were staying in the same house. When the wife of the accused died, his elder child, and one the living room and the other is kitchen. And from the spot map, that is your last can see, a small house.
2 rooms.
That is at page 157. A. It is the house. That person was there inside the house, bolted the door from inside. And no plea has been taken, and no substantially, no, he has not answered as to how his wife has died. That is all this.
Yes, sir.
If your lordship will permit me, my lord, reply in few words in reply, my lord. My lord, the first point, urged by my friend, the State Council, my lord, that plea of alibi has not been taken. It's not correct, my lord. In view of the accused statement, page 65 of the paper book, question number 440, my lord. Have you anything more to say? Here, my lord, I have mentioned Truptiranjana Das, PW1, ଓ ତାଙ୍କ ବାପାଙ୍କ ସହିତ ଆମର ଜମି ଜମା ପାଇଁ ଝଗଡା ଥିଲା। ମୁଁ 7/7/97 ତାରିଖ ରାତି 9ଟାରେ ସ୍କୁଲରୁ ଘରକୁ ଆସିଲା ବେଳେ ପୋଲିସ ମତେ ଧରିଲା। So my lord, that I had dispute between I have dispute with the family of PW1. While I was coming from the school, my lord, then police caught me. That itself, my lord, the plea of alibi is, my lord, I was not present at the spot. Therefore, my friend, Mr. Kotik has said that, my lord, that even if he was not present at the spot, but the distance is so less, my lord, it is also possible to come and commit the crime. So it cannot be possible on the human conduct, my lord. It cannot be possible, my lord. Somebody committing the crime in the school and again going back and joining the school meeting. It is not possible because the headmaster, either the defense witness has to be accepted or rejected. That is another thing, my lord. But once the headmaster's statement and the exhibits are accepted, my lord, and that he was present till 9:45 p.m., my lord, and exactly by that time police has reached and by that time murder was committed, my lord. So, and once in question number 40, answer to question number 40, it is stated that I was not present, I was in the school, my lord. Rati 7/7, he was at the school, my lord. Therefore, the plea of alibi has been taken. Then, my lord, the State Council has also stated, I have taken down, my lord, that dhoti was containing blood. So in that aspect, my lord, the witness who was stated he was in the police station, whether your lordship will accept or not, that your lordship will decide. Your lordship said what kind of a witness, my lord, that is he has case against him, my lord, whether your lordship will accept or not. But he was wearing a trouser, my lord. And regarding the seizure of finding of a blood stain on the dhoti, and there are decisions, my lord, I will also cite decision. There are decisions, my lord, that merely because the dhoti or the dress of the accused contain blood stain, my lord, unless the blood group of the accused is also examined, also done, so it cannot be conclusively said, it cannot be concluded, my lord, that the blood stain which was found on the dhoti or on the dress material of the accused is definitely the blood of the deceased. It cannot be conclusive, my lord. I will cite also decisions. I have found some decisions. I will cite that, my lord, because the blood grouping of the accused has not been done, having not been done merely because some blood was found on the dress material of the accused. That cannot be a ground to conclusively come to a finding that he is the killer, or because of the killing or because of this act of murder, his dhoti contains blood. Then, my lord, regarding torture of a demand of a dowry, my friend has relied on the statement of PW 15. For a moment, your lordship may kindly come to the statement of PW 15. At page 105.
Yes.
My lord.
Yes.
So, my friend, Mr. Kotika, relied on the evidence of this witness, my lord, to prove, to show your lordship that there was torture on account of a demand of dowry. I am the elder sister of the deceased Sanju. The accused in the truck is the husband of my deceased. The marriage between Sanju.
He has read this whole evidence.
Pardon?
He has already read this whole evidence. Which portion do you want to read?
Yes. Your lordship may kindly see. First of all, my lord, lordship may kindly see page 106. para 4 of the cross-examination at page 106 of the paperwork. I was given in marriage 7 to 8 years before the marriage of Sanju. Sanju is the deceased, my lord. Sanju is the deceased, my lord. He was, this lady, my lord, she was given 7 to 8 years before the marriage. Your lordship may kindly think of, my lord, a married sister who was given in marriage 7 to 8 years before the marriage of the deceased. How she is not supposed to have any knowledge regarding torture on account of a demand of dowry. He is not the brother. He is a sister married much before the marriage of this girl, my lord. So he has stated that I have married 7 to 8 years before the marriage of Sanju. My maternal uncle and brother-in-law had arranged the marriage of Sanju. So my humble submission before lordship is, it is usually expected the persons who have arranged the marriage, maternal uncle and brother who has arranged the marriage, my lord, they should have stated, my lord, regarding the demand of dowry. They have not uttered a single word. And uncle and brother-in-law had married the marriage of Sanju. They look after the marriage affairs. I have heard from the brother-in-law, Pramod Patnaik, that he paid rupees 12,000 to the accused persons in presence of Devendra. It is not a fact. So my humble submission, my lord, that he has heard this. He has no direct knowledge. He admits that I have heard from my others. And here also he has said, I have heard from my brother-in-law, Pramod Patnaik. And Pramod Patnaik, my lord, Pramod Patnaik, my lord, from whom she has had and stated this. Pramod Patnaik has been examined as a witness, my lord. Pramod Patnaik is PW 6 at page 78. My lord, this witness on whom Mr. State Counsel relies, that she is a competent witness to depose regarding the torture on account of a demand of dowry. She herself admitted that I have no personal knowledge and I have heard it from a Pramod Patnaik. If Pramod Patnaik, what your lordship may kindly see then, what Pramod Patnaik has stated, who has been examined as PW 6 at page 78. He has not supported my lord, for which he was declared hostile. I have not given any money. Your lordship may kindly see page 79. First of all, your lordship may kindly see page 78.
Yes.
My lordship may kindly see page 78, my lord.
Yes.
78, my lord. I know the accused standing in the dock. The accused had married Sanjukta, my sister of my wife, on 12/7/93, as per Hindu rites and customs. Sanjukta died on 7/7/97 night. I do not know if there was any demand of dowry.
So you're completely missing the point, but we don't want to get into that. Anyway,
my
you
lord,
argue whichever way you want.
My lord.
All right, sir. All right.
Your lordship.
No problems. Carry on. Yes.
I do not know if there was any demand of dowry. The marriage, I attended the marriage on son-in-law. I had no business to interfere in the matter, but I have seen portable TV, etc. Then your lordship may kindly see next page. I have not given any money. Next page, my lord. I have not given any money to the accused in presence of his brother-in-law, and cousin brother towards the demand of dowry.
Anything else, sir? Anything else?
So, my lord, my humble submission is, my lord.
Yes.
So, for 302 is concerned, the circumstances which has been pointed out by the State Council or is relied in the judgment, my lord, is not conclusive. And your lordship know, my lord, in the case of Sarath Biranchi, which is the leading case, unless all this link of all the circumstances is clearly made out of proof, my lord, no conviction can be based on the circumstance evidence, my lord. Here is a case, my lord. The circumstances are very weak, and all the circumstances has not been clinchingly proved so as to prove the guilt of the accused beyond all reasonable doubt. So, for 304B is concerned, my lord, although the witnesses who are competent, they have not supported the case. Again, most respectfully, I submit, my lord, even if the witnesses are declared hostile, merely because the witnesses have declared hostile, your lordship, the law is, my lord, cannot be completely thrown out. Your lordship also can accept the portions, and witness turned hostile means, my lord, a competent witness has not supported the prosecution case merely because he was turned hostile and he was declared hostile. Therefore, his evidence is complete, should be thrown out, and the witness who have stated something against the prosecution, that is to accept. That is not the.
And he is the nephew of the accused, sister's son.
Not to be accepted, my lord. And she has no direct knowledge. She relies on the statement of PW8, who has said that, on the statement of other witness who have said that there is absolutely no demand of dowry. So in view of this, my lord, neither case under section 304.
Lordship give permission to citations may.
We can give all that later. Orders reserved.
My lord, your lordship, permit me to give the citations also in this
Yes,
case.
yes. Please do that.
Yes, short note with citations.
Keep this with the paper. Orders reserved. All right.
May I pray, my
Continue
lord?
after lunch.
May I pray, my lord? I have a small prayer, my lord. Will your lordship accommodate me for the day, because I have some 3 to 4 other matters, my lord.
Let us see, sir, when the matters are called out.
Supplementary list item number 13.
May I please, your lordship? Lordship, this is a case of your lordship on last date on 13647. Your lordship has directed to the government to take instruction on the matter. My prayer was that, lordship, in that case, without measuring the high tide line and the coastal regulatory zone, and without giving any individual notice, they have demolished the pond, lordship. And state is to file the counter, lordship, in this case. The Tahsildar
13647 of 2021, that your lordship may fix it to next week. Individually, this may be listed. I will file the counter and Mr. Biswala's case, because I will take 1 week time for.
Lordship, allowed your lordship, in this case, what has happened, they have not given any individual notice, lordship. They have demolished around 15 persons recorded land span. That is my concern, lordship.
Any short date maybe
13647.
Lordship.
13647.
IA number 13647. Mr. Mohanty seeks and is granted 1 more week's time to file a reply to this application.
It can be listed separately. This can be listed separately so far as this particular.
Let's see. Then.
My lord, in the main matter, I'm on BC, my lord. I'm sorry.
Yes.
The Kendrapara collector was to reconcile the satellite data with the ground, so that how many gheris are left, we have to.
Affidavit.
That has not done since last months.
That affidavit we have filed on behalf of the collector Kendrapada. Your lordship may kindly see para 6 of that affidavit. 5 and 6.
Is it a flag or?
This is a flag. The hard copy I am supplying to your lordship.
Copy may also be supplied to me, the officers now.
So you are there, how can I? Samasta, all. Para 5 and 6 of the affidavit may kindly be produced. And we have also annexed the status report provided by the concerned Tahsildar, that is Rajnagar and Kanika. That available at page 6 and
You have to serve a copy on Mr. Mohit Agarwal.
Yes, but he is there. Otherwise, I could have.
All right. You say an affidavit dated 22nd June 2022 has been submitted by the collector Kendrapada, enclosing the reports of the Tahsildar Raj Kanika.
4462. Yes.
regarding superimposition of locations as per satellite map over cadastral maps. One report covers 74 villages and the other 151 villages. It is claimed that 59 plots with active illegal prawnggeries were identified as being inside the high tide line, of which have been issued notice to discontinue the illegal practice. Stop 26 of them are claimed to have been demolished. They stated that in 23 other villages, eviction action has been commenced. Stop. The collector undertakes to file a further affidavit regarding the further compliance affidavit before the next date. A copy of this affidavit shall be served on the amicus curiae within 2 days. What else?
Then your lordship may kindly take up IA number 4462 of 2022, in which direction was issued to us for undertaking an inspection, spot inspection.
Flag 161, my lord.
We have submitted the inspection report in our objection that filed on 21st June 2022. If your lordship wants, we can give the hard copy also.
One.
4462 of 2022.
Right. What is your finding?
Yes, finding is that page 9 may kindly be seen. The inspection report. It was identified that no Sthitivan private land as spread for under Khata number so-and-so, plot number so-and-so, Mauja Sitaram, and Khata number so-and-so, Mauja Mangjudi, under Tangi are coming within 200 meters of HTL of the Chilka Lake, even though the plenty prays for a limit of 100 meters from the HTL. Further, no coconut trees and farmhouses exist within 200 meters of the HTL of the Chilka Lake. It can be inferred that due to the ongoing eviction drive against illegal ponds coming within 200 meters of the HTL as per the order of the Honorable Court in the WC1. So the interveners have anticipated coercive action and opted to intervene in the proceeding. So we are not going to take any coercive action against the petitioners because their suit land is not within the...
All right. IA 4462 of 20.
But we have demolished some portion of our land. But they have already demolished some portion of our land.
That is not our...
This is the entire...
An affidavit dated 21st June 2022 has been filed, stating that none of the lands of the interveners in this application in the Khata numbers indicated are coming within the 200 meters of the high tide line bracket HTL of Chilka Lake, and no coconut trees and farmhouse exists either. The affidavit is placed on record. In view of the above affidavit, Mr. Mohanty states that there is no coercive actions proposed to be taken against any of the applicants in IA 4462 of 2022. The statement is placed on record and the application is disposed of.
In your lordship,
may suggest, my lord, because the Chilka man lord knows that 100-meter restriction is there. What their district administration doing? They are demolishing 200 meters. My last occasion, I placed the rules and placed the lord's notification issued by the authority, my lords. Where so far as Chilka is concerned, CRZ apply only 100 meters, and so far as C is concerned, it apply 200 meters. But they are, my lords, misinterpreting the provision. They are demolishing 200 meters. That's why, my lords, I pray, my lord, let it be clarified so that, my lords,
no, they themselves know. That's how they're filing these affidavits.
Yes, my lords.
But my lord has
They are also
specifically,
filed this affidavit.
yes, my lord had specifically observed in the earlier rider.
So that's enough. That is serving the purpose.
The
So
his purpose is solved. Now
My
he's saying for
purpose is
others.
solved. My purpose
Then
is
you-
solved. But so far as to avoid multiplicity of proceeding,
No, they are
because
aware.
they are demolishing 200 meters. That is the entire case.
But they are aware this affidavit itself, they themselves say there's nothing within 200 meters.
Yes, that. Then your lordship may kindly take up IA number 5774 of 2022. This is an IA in which we have filed our counter affidavit, which is very important. Your lordship may kindly see page 3. During the, has your lordship got it? Exactly.
Yes.
Page 3.
Yes.
During the course of field inquiry, it is pointed out that an earthen pond is situated in 2 revenue villages on the following land schedule, which fish farming is continuing. Some earthen ponds have been found over the remaining area of plot number so and so. All ponds are dry. More than so and so. Details are given. As per the map supplied by Orissa and Chilika Development Authority, as well as cadastral map, that part of the lands in possession of the applicants comes under the no development zone. That it is submitted that steps will be taken to demolish the gheris and earthen ponds which are coming under the 100 meters considered as no development zone. It is a fact that till date the ponds of the applicants have not been demolished. So, and that in view of the aforesaid, this honorable may be pleased to grant permission to the deponent herein to carve out and to carry out demolition and eviction of the illegal gheris, earthen ponds, so and so present at the
No,
land
but
schedule.
this affidavit, you say the applicant has no legal right of the land.
No.
Yes. Yeah. Para 6.
Yes, he has no legal right over the land. That there is no
So
valid.
who's appearing in this 5774?
It was only till for 1 year.
All right. IA 5774 of 2022.
That status order is there. That is why.
Yeah, it will get vacated. An affidavit dated 21st June 2022 has been filed by the Tahsildar Chilika, stating that the applicant had been allowed to operate the source, that is Sabik plot number 233 under Khata number 116 Rakhita Anabadi, with an area of AC 81.679 decimal. From 1st April 2002 to 31st March 2003 as the highest bidder, after which the source has not been auctioned. It is accordingly submitted that the applicant has no legal right over the land. It is the land in question is recorded with Kisam Gochar, and at present it is a government land. It is stated that steps will be taken to demolish the gheris and earthen ponds coming under the 100 meters considered as no development zone. In that view of the matter, the status quo ordered earlier is vacated. The application is disposed of. It will be open to the authorities to take appropriate action in accordance with law.
Then I would like to place before your lordship the affidavit of Ganjam collector on behalf of Ganjam district that is dated 22nd June 2022. The deponent is the Tahsildar Ganjam, and lordship may kindly have a glance. Para 3. Is it there? This is for Ganjam district.
Yes.
Para 3. May kindly. This affidavit is filed in the writ petition itself. No IA. Status report.
Yes.
That it is humbly submitted that the task force team constituted by the sub-collector Ganjam has been instructed to ensure there is no re-emergence of the illegal prawn gheris after eviction has been done by the concerned Tahsildar in consultation with the police official. In this connection, Tahsildar Ganjam and Khalikot have jointly visited the field along with the representatives of fisheries and revenue staff. During their visit, 2 gheris had re-emerged, that is one in Ganjam and one in Khalikot Tahsil. The re-emerged Gheri has been demolished by Tahsildar Ganjam in presence of representatives of revenue, fisheries and police personnel on 25/2/2022. Similarly, Tahsildar Khalikot has demolished the re-emerged Gheri on 8/6/22 and lodged FIR against the encroachers. The factum of demolition will be evident from the photographs annexed to the present affidavit. The Tahsildar Ganjam, by its letter number so-and-so, has intimated the fact of demolition drive conducted on 25/5/22 to the sub-collector of Chhatrapur. Similarly, the Tahsildar Khalikot has also intimated copies of the photographs so and so, so and so. So we have already demolished the re-emerged Gheri, and these two Tahsildars have submitted report to the collector. That is, photographs also we have annexed to the affidavit. That may kindly be taken into consideration.
The Collector Ganjam has filed an affidavit dated 22nd June 2022, inter alia stating that the Tahsildars of Ganjam and Khalikot visited the field and noticed two Gheris, illegal Gheris having re-emerged, one in Ganjam and another in Khalikot Tahsil, and both are stated to have been demolished on 25th February 2022. On 25th May 2022. They stated that in FIRs, the Khalikot Gheri illegal Gheri was demolished on 8 June 2022. It is stated that the FIR has been lodged against the encroachers. The photographs showing the demolition action have been enclosed. The said affidavit is taken on record. It is assured that the district administration will carry out regular surveillance and ensure that the illegal Gheris do not re-emerge.
I will let them file up-to-date status reports as to how many Gheris have left.
A
further revised status report we filed before.
We will file the status on the next date.
Right.
Then I would like to place before Lordship the collector Puri's affidavit. That is hard copy I have supplied. This affidavit is dated 24th June or 26th June. 26th June. I'm sorry, 21st June. Page 5, that is the inspection in para 6. It relates to two Tahsil, Krishna Prasad and Brahmagiri Tahsil. Here we have mentioned the name of the villages and where the eviction have been undertaken, found that there is no net Gheris. I have stated all these villages, we have found that there is no other net Gheris. And the answering deponent undertakes that as and when any information is received regarding re-emergence of illegal prawn Gheris through helpline number, immediately steps will be taken to demolish such Gheris. Copy of the letter. And another important, your Lordship may kindly have a glance over para 7. That is most important. At page 6, that the answering deponent humbly submits that the Tahsildar Krishna Prasad Bhai so-and-so, letter number so-and-so, has intimated that to carry out further eviction, the area within 200 meters was difficult to be ascertained, and therefore he had requested to move the CDA authority to identify the area which is within 200 meters of the high tide line. Copy of the letter number so-and-so, Tahsildar Prasad annexed to it. That the answering opposite party humbly submits that the Chief Executive CDA Bhubaneswar was requested by the office letter number so-and-so to take early steps for identification. And I pray before your Lordship that the CDA may be also, there should be an observation that CDA will help cooperate with the district administration to identify that particular land as requested by us in this particular letter of this collector.
An affidavit dated 21st June 2022 has been filed by the collector Puri, where inter alia the steps taken to patrol the area where illegal prawn Gheris have been demolished have been set out. Stop. Some instances of the re-emergence of the illegal prawn Gheris and their demolition have been set out. Full stop. The complaints received have also been acted upon. And the task force is stated to have visited the Geris on 16th June 2022 and found no re-emergence of those Geris that had been demolished earlier. Paragraph. The affidavit specifically states that on 11th May 2022, Tahsildar Krishna Prasad has expressed difficulties in ascertaining the precise area within the 200 meters line, high tide line. Full stop. In this connection, on 1st June 2022, the Chilika Development Authority (CDA) has been requested to take early steps for identification of HTL within 200 meters in Chilika Lake, so that the eviction program could be taken up.
Yes.
They should be within 100 meters or 200 meters.
This is 100 meters. For Chilika is 100 meters. They himself are admitted in their affidavit.
We have requested for 200 meters following that CRZ notification. That
anyway, whenever they demolish, we'll see. A direction is issued to the CDA to extend all its full cooperation to the collectors of Puri, Ganjam,
another
Kendrapada
affidavit I want to place before your
and
lordship.
Khurda, to enable them to take effective steps by assisting in the identification of the HTL.
Lordship, another affidavit, your lordship may kindly have a glance. That is Collector Khurda's affidavit. That is also on 22nd 6. And we have given the status report in that at page 6, 4, 5, and 3 to 6. The status report. What steps we have taken, and
likewise another affidavit has been filed on 22nd June 2022 by the Collector Khurda.
This is in compliance of the earlier
Detection and
order
demolition of the illegal prawn jetties and the lodging of FIRs. The said affidavit is taken into account. There are some more IAs, no?
No, I think there is no, except that IA of Mr. Biswara, there is no other IA.
No, there was an 8415 and 8416. Nobody's appearing today.
Lordship, may I request this court on this annual court? Earlier, they have put concrete pillar to demarcate that CRZ zone. That concrete pillar, few of the concrete pillars are also still lying in some portion of the Chilka belt under the Tahsildar Chilka and Tahsildar Tangi Lordship. What do you request? Why they don't put that concrete pillar so that we can know that this is the CRZ zone and this is the coastal regulatory zone, and we will do the cultivation 200 meters away from that. We, the farmers, we are not aware of this fact, Lordship. So we sincerely request, let them put the concrete pillar by measuring either the CTA.
After identification, it will be done. He is correct in his approach, but after identification, we will pursue.
That's only we request, Lordship.
That is there.
Wherever the HTL has been able to be identified, the earlier system of indicating it by concrete pillars, embedded concrete pillars should be adopted.
Yes.
Lordship, one more issue of pollution that is, I think, getting sidelined because of this Geri issue. The entire ecosystem of the lake depends upon the quality of water which drains into the lake. And the river Daya is a river which drains its water into the lake. And all the untreated water of domestic and industrial use from Bhubaneswar falls into that river, and untreated water goes to the lake. So it is apparent that the quality of water in the lake is deteriorating day by day.
This is,
so in my flag,
this is completely
in my flag
different, not within the scope of
No, no,
the
it is
PIL. If you
No,
then
it is
only,
within the
then
scope of
we
this
have to again ask the pollution control board to.
So Mr. Yeah, we can ask the pollution control board to undertake tests and tell us.
Yes. Flag 3. Your
And
lordship
first, that pollution control board may be included as a party. Notice should go to the pollution. Then only all these things can be taken care
My
of.
lord, five issues have been framed, out of which this is the second issue. And
No,
at
but is
flag
the pollution
3,
control board a party, Mr. Agarwal?
No.
No, my lord, they may be added by
Yes.
they and
On
the
the
BMC,
question of pollution.
Municipal Corporation.
Only Chilika Lake, is it?
And also for Bhitar Kanika, there the water of river Brahmani empties into the Bhitar Kanika, and from NALCO and the Fertilizer Corporation of India, Talcher Thermal Power Plant, all those wastes go into that. So they have to undertake tests, my lord. In my flag 3, I have highlighted, and the second issue is there, pollution.
Pollution
so
of
may-
lakes in Chilika, lakes in Chilika and Bhitar Kanika. Mr. Mohit Agarwal and AAC has urged that this court should issue time-bound directions to the State Pollution Control Board to test the quality of the water in both Chilika Lake as well as the Bhitar Kanika lagoon. Bhitar Kanika is not a lake, sir. It's a lagoon.
It's a wetland, lagoon type.
Lagoon, yeah. Lagoons. Stop. A direction is issued to the a direction is issued that the Orissa State Pollution Control Board will be included as an opposite party in the present petition. Mr. Agarwal will file a revised memo of parties within a week. Notice be issued to the Orissa State Pollution Control Board to a direction is issued, sir, to the Orissa to depute technical teams to test the quality of the water in both Chilika Lake as well as the Bhitar Kanika Lagoon, and file a report in this court containing the test results and the suggestions of the Pollution Control Board for improving the quality of water in both lakes.
Lordship, very recently,
both water bodies.
Lordship, very recently, they have inducted one Garuda, one flotil inside Chilka water by investing 10 crores. And State Pollution Control Board and Chilka Development Authority may also can be directed to file the respective affidavit on that. On this pollution point of view, Lordship.
Registry may be directed to
10 days before they have inducted this Garuda into
already
service.
communicated to the Secretary, Orissa State Pollution Control Board for compliance.
Yes.
So that will take it up as a separate petition, sir. That
registry may just
float and all. Let's not add it here. That
now
becomes
attempt is being made to expand the scope of the PIL, but we should confine to the illegal prawn gheris. That is my respectful submission.
That is not the only issue. There are 5 issues. That's a
And I am thankful to the amicus curiae because of his hard work. Now all these illegal prawn gheris are decreased like anything.
Date.
So he should.
August is what?
My lord, I just pray the registry may add the pollution board as a party.
Yeah, we already added as a party. I've asked you to file a memo of party so that notice without processing will go to the Orissa State Pollution Control Board, and a copy of this order will also be sent to them through their secretary.
Lordship is the fountain of justice, Lordship. Lordship, may I request, we are all concerned about this protection of the environment inside Chilka Lake, Lordship. And because of the prawn cultivation, environment of Chilka is going to be destroyed. That is the presumption, general presumption, Lordship. What we propose, by 1% of the Chilka water, there can be on trial and error basis, let there be a prawn cultivation under the direct supervision of any of the state agencies, be it the CDA or district fisheries officer or the revenue department. They will not put any seeds, no fertilizer, no hormone, nothing of any sort. Simply put the prawn seeds in the water, keep it for 4 months, Lordship. If they grow to its natural process, they grow, Lordship, that we can draw, this honorable court can got the presumption out of that whether this prawn cultivation across Chilka around that causing environmental pollution or not causing any pollution, Lordship. Can it be possible, Lordship, on 1% of the Chilka water?
No,
Chilka, Lordship, that
they
is
are
under the
going to
direct
order
supervision
them
of the
to do all
states, Lordship. We are all concerned because every day, what is happening, Lordship, it is a bread and butter issue of the people across Chilka, Lordship. Vis-a-vis the environmental protection on the Chilka Lake.
So it has become greed, sir. That's the whole problem.
No, Lordship, it is not question of greed. It is the life and
no. That's only one part.
People's
That's only
across
one
Chilka.
part of the
That
story,
is-
sir. That's only one part of the story.
In 4 months, Lordship, nothing will happen.
Yes.
Suppose in 1 square kilometer, this prawn cultivation would be there. No pesticides, nothing will be put to that. That will be under the direct supervision of the state. And if the in the natural process, the prawn grows without causing any causing any hazards to the environment. I think, Lordship, that can ameliorate the situation, Lordship.
No. See, list on 11th August at 2 p.m.
11th August.
Yes.
And the question of coconut plantation across Chilka, they can put for the protection of the environment. Chilka Development Authority spending money on this floating this Garuda by spending 10 crores. They can put the coconut tree at all. They can, if they are at all interested for protection of the environment across the Chilka water. Because the decomposed soil that can the coconut tree can consume the decomposed soil. In the natural process, that can also be that can increase the economic condition of the people across Chilka, Lordship, in that process.
It's all right. Consider the next step.
Supplementary list for hearing item number 20.
Item 20, my lords. On behalf of Mr. Manas Kumar Swain, the paper book has just been received by us from the High Court Legal Services Authority, my lords.
The 2001 matter, sir.
My lords, I pray for 1 week's time to go through the full paper book and prepare, my lords.
How do we never seem to take up jail criminal appeals at all?
8 days prior, we received the paper book, my lords.
It's all right. That's more than enough, sir, to get ready with the matter.
My lords, sir. I pray for 1 week's time.
All right. At the request of counsel, the appellant, 7 July.
Grateful, my lords.
Supplementary list item number 21.
Your Lordship, item 21 on behalf of Mr. D. Naik, I'm seeking an adjournment. He had asked for an accommodation before Your Lordship today.
It's all old matters. Sir.
Yes, Your Lordship, we are prepared with the matter.
Then let it stay on board. Then.
Yes, Your Lordship, let it stay. Obliged.
Supplementary list item 22.
Who's from the state in this matter? 22. No, Mr. Katika, you are appearing 22.
Yes, sir.
You're in 22?
Yes.
Let's start.
Madam, Jail Criminal Appeal number 31 of 2012. I have not prepared. I will submit today. Criminal Appeal 71 of 2006.
So it's all common paper book. It's a common judgment.
I have not prepared that.
So how can you prepare in one and not in the other, sir? It's all evidence is the common evidence.
No, I am prepared only 71 of 2006.
How can it be? I don't understand. Just the two accused, right?
Yes, two. One is dead.
What is that to prepare?
95 by 2004. That has been abated.
Madam, this accused, Parikita Behera, has torn mad. I have not sought, I have sought instructions, but not yet received. That's why I am praying for 2 weeks' time. To
whose appeal is abated?
No, sir. That is JCRL 95 by 2004. Dhani alias Dhaneshwar Behera.
He is dead, my lord.
The last date was that was brought to your lordship's kind notice, and the appeal has been
Is it shown today's cause list? The criminal appeal is not there.
That is not there. That has been disposed of.
Then, so only two criminal appeals: 71 of 2006 and 31 of 2012.
Madam. Your lordship, I pray your lordship may kindly call it 2 weeks after. I will take instruction. I will do both the matters at a time.
It will stay on board, sir. It will stay on board. Next week it will come.
2 weeks after, my lord.
Next week, sir, please don't take us so much for granted.
Next
We are
week.
just being indulgent to you. Please don't take us for granted. Please get ready next week. Yes.
Next week, my lord.
Supplementary item 23.
Yes.
Item number 23.
Maybe.
Yes, please.
Pursuant to the order of the day, the appellant has present today. And you have not filed. Today I am appearing in this case.
Yes, virtually, I was appearing in this case. My name still appears in the call list. My name will be deleted, sir.
But who's for the state?
And the appellant has come.
He's here.
Appellant is here.
Hello. By the last order, your lordship has caused this person.
Sudhir Roja. Where is he?
Stay on board.
The name of Mr. Katke not be shown for the appellant in the past. Mr. N. Hota appears on behalf of the appellant who is present in court. He need not appear till further orders. Mr. Hota seeks and is granted time to get ready the arguments. List on 14 July.
My name will be deleted.
Already ordered that, sir.
Supplementary list item number 24. Item number 24.
You are appearing in both these matters, Sudhir Roja and Pradeep Mohanty.
No, my lord. For only Sudhir Oja.
Then who's appearing in that Pradeep Mohanty's case?
It's a potent.
Who's appearing for the appellant in that connected case? Hmm? So can we request you to appear in that also?
I was also appearing that, but Chittaranjan Sahu in the meantime has entered appearance.
But no, you see, Criminal Appeal 432 of 2006, none appears for the appellant despite a pass. The court requests Mr. Niranjan Hota, who's already appearing in the appeal of the co-accused, to also appear in this appeal.
My name Niranjan Hota is previous counsel. My name.
What is your name?
Pulokesh Mohanty.
You write it out. Everywhere you have to put this name down. We request him to appear for the appellant in Criminal Appeal 432 of 2006 as well. You appear in both these.
All right.
All right. 14.
Supplementary list item number 24. Item 24.
We had asked this should be assigned to the 9th March order. Mr. S.K. Kanungo, who had been assigned this case by the High Court Legal Services Committee, has not appeared today. The Secretary HCLC will ensure that Mr. Kanungo is present on the next date. Copy of this order be sent to the secretary, OHCLSC, forthwith. List on 14.
Supplementary list item number 25.
Here I have one difficulty. I mentioned for bail, but it has come up for hearing. I can also assist your lordship so far as the hearing is concerned. But the noting is that paper book is ready. I was inquiring from my friend. He has got a copy of the paper book. I have not been provided with a copy of the paper book. May I pray, my lord? I may be also.
All right. Mr. Mishra states that he will collect a
But
copy.
this may be, and one more thing I was praying, my subject to your lordship's kind consideration. There is a bail application in place. He is 13 years in custody. Will your lordship
appeal itself, sir?
As your lordship pleases. Then the appeal may be hard, my lord, your lordship.
Yeah. Mr. Samir Mishra is permitted to collect a copy of the paper book from the registry. When do you want it?
If it is taken up next week also, I'll do it. Today I would have done it, but I don't have the
I'm ready.
defense witness copy.
List on 7 July.
My obliged.
Weekly list, old matter item number 1.
My lord, item number 1, my learned senior was waiting, but he is on his legs in another court. I pray my lord may taken up as the last matter today.
All right.
Weekly list item number 2.
Please, your lordship, my lord, my senior had argued in the supplemental list item number 19 and prayed for accommodation of the.
Stay on board, stay on.
Obliged.
Weekly list item number 3.
Wait, please, lordship.
Yes.
I have prepared written order submission also. I am not placing the written order submission, only it will unnecessary kill time, my lord. But I am prepared written order submission along with judgment, so lordship kindly come. My lord, dear lordship, the fact here is there was vote again. I'm sorry, my lord. There was a enmity between two persons. Both the persons have died. But the deceased, presently the deceased in this case, the deceased daughter was having some love relationship with another man called Tapan. But the prosecution evidence also says that the deceased and Tapan are chasing each other. And thereafter, my lord, Tapan has also been injured. Subsequently, Tapan died. But the Bisham present deceased is concerned, my lord, when the accused person chased the deceased and the deceased went inside the house of PW3, and inside the house, the accused persons entered into the house and dragged some accused persons and dragged the deceased from inside the room, one of the rooms of PW3, and in inner courtyard they assaulted him and he succumbed to his injuries. My lord, may kindly see, but 3 witnesses were very important in this case, and there is only one eyewitness. Lord, may kindly see PW3, in whose house the incident took place, my lord.
Yes.
Because FIR is in the FIR is not necessary, my lord. Lord, may kindly see PW3 page. Page 59, my lord. Page 59.
Yes.
I know all the accused persons.
The accused is also Trinath and.
Sorry, my lord.
The informant is also Trinath. The accused was.
He is the informant also. He is the informant also.
Okay.
I know all the accused persons, and to deceased Bishamitra, I am the informant. Incident took place on 23/5/94 at about 8 a.m. near my house. I was sitting at the shop of Satyagna Sahu, who is also DW2. At that time, I saw all the accused chasing Bishamitra, the deceased, with Lucky and Bishamitra deceased, concealed himself in my house. Sivatsa, actually probably it will be Srinivas, was armed with a crowbar which has not been seized, and others are armed with lathi. Srinivas and Subal, Srinivas is appellant number 1 and Subal is at appellant number 7, threatened me and asked me to bring out Vishwamitra from my house as they want to kill him. I advised them to call police and Gramaraki. Then they joined other Rakis in our house. As soon as they arrived at my house, my wife and my mother, his wife is PW5 and mother is PW4, told me that accused persons killed Vishwamitra by entering in our house. My wife and mother were inside the house when the accused persons went there. I saw Vishwamitra deceased lying with the injury below the inner veranda of my house, His head was fractured and blood was coming out from all over his body. The door and the floor and courtyard were stained with blood. Vishwamitra was dead by then. The accused persons were not at the spot. The lathi stained with blood were lying at the spot. I reported at the PS Exhibit 2. Is the FIR. Exhibit 2/1 is my signature. Police came to the spot and held inquest over the dead body, prepared the inquest report. PW3 is the said report. Exhibit 3/1 is my signature. Police seized the lathi, tangi crowbar from the spot and removed the dead body from the for postmortem. The Umakanti is the daughter of Vishwamitra, deceased. Tapan is the son of Srinivas, appellant number 1. As they were in love, a meeting was held at the village at the instance of Vishwamitra. The accused and Vishwamitra reside in the same different blocks of the village. I have no knowledge about the prior incident prior to this occurrence. I do not remember if I mentioned in my affair that Vishwamitra deceased chased Tapan with a tangi on the date of incident and assaulted him. I had not seen Tapan at the spot. It is not a fact that I had not mentioned in my affair that my wife PW3 and mother PW4 told me that the accused persons killed Vishwamitra. It is not a fact that I had not stated to the IO that my mother and wife were present at the house. The shop of Satyagna DW2 is in different block than that of my house. I had seen only Srinivas, appellant number 1, and Subal, appellant number 7. The shop of Satyagna is not in between my house and house of Srinivas, appellant number 1. And appellant number 1 and Satyagna is not in between. Sorry, some other persons were at the shop, but I do not remember their names. DW3, sorry, Ramesh, DW3, and Ravindra are my eastern neighbors. And Digambar and Ratnakar, Akshay and Pitabas were my eastern neighbors. Nareshwar, DW4, my front door neighbor. Tapan, another dead person. Tapan was dead. It is not a fact that Tapan murdered Vishwanath and I am deposing falsely getting them. But here the most important aspect is that PW3, in whose house the occurrence took place, he says before the court that when he came to the house after the occurrence, his wife and mother, PW4 and 5, they informed him, and that part he has not stated in the affair. That is the matter. Then you will also kindly see PW4, the lady, his mother. The 3 witnesses are relevant here only. Page 62.
Yes.
I know the accused and accused persons. Vishwamitra was killed 7 years back in the morning at about 8 a.m. inside my house. Myself and daughter-in-law Sukanti were present at the house. Tinath had been to the shop of Satyagna. I was at the cattle shed to remove the cow dung. I saw Subal, appellant number 7, and with body. Baidya, appellant number 6, with a wooden plank, and Neela, appellant number 10, without arm. And Subal, appellant number 7, was shouting to kill Vishwamitra, who entered into our house. Out of fear, I went away. I had not seen the other persons. 5 minutes thereafter, I returned to the house and saw the dead body of Vishwamitra inside my house with bleeding injury. Of course, my eyesight was not good for last 10 years, and I was not able to identify immediately, even to my relatives. The cattle shed is at a distance of 30 to 40 cubits from my house. It is not a fact that person to whom I saw were in the front side of my house. Subal appellant number 6, by the appellant number 6, Subal appellant number 7 and by the appellant number 6 and Nila appellant number 10 were found at the inner veranda where Vishwamitra was Vishwamitra was. My house consists of 6 rooms. By witnessing the Hala, I went away to the backside through Bari. I have not stated this thing to anywhere before depositing this court. I had not seen any other member inside my house. I returned to my house afternoon. I had not raised any Hala out of fear. My son, PW3, returned to my house after arrival. Sukhanti, PW5, came later on. I heard about the love affairs of Tapan with Uma, daughter of Vishwamitra, the deceased, and had the Vishwamitra had that Vishwamitra assaulted to Tapan and Tapan assaulted to Vishwamitra. My lord, here, my lord, the 2 important aspects are there. First of all, she has named 3 appellants only. They say that she saw appellant 7, 6, and 10. 7 was shouting to kill, and 6 was she was appellant number 6 was with a wooden plank that is not seized by the police, and Nila appellant number 10 without arm. And all injuries, I'll come to injuries part later on, my lord. Then, my lord, another thing that his eyesight is so poor that he was not able to identify even from his close relationship also she was not able to identify. So when she was not able to identify even close relations, even there is no scope for her to identify these 3 appellants at least. And after all, he has seen only 3 appellants, not no other person. After all, if her evidence to be accepted that she had seen those appellants, because her evidence, in view of her own admission, that she was not able to see, her eyesight was so poor that was not able to identify the close relations. So it was not possible for her to identify even these 2 appellants, the 3 appellants. Then, my lord, another thing, here's the her statement, her deposition is that whatever she says that for the first time I'm coming to court and stated. So that before the police has not stated anything. Then, my lord, PW5, who claims to be the eyewitness, the wife of PW3. I know accused Vishwamitra and all accused Vishwamitra and murdered 7 years back. I was at the kitchen room on the date of incident. My mother-in-law was going to cattle shed and my husband had been to the shop of Satugna TW2. Vishwamitra entered into her house from Danda. Vishwamitra is deceased. Entered into the house from Danda and entered into a bedroom and closed the door from inside the room. Here she names of appellant Srinivas, appellant number 1, by the appellant number 6. Rohit, appellant number 8, Subal, appellant number 7, Himakshu, appellant number 9, Gautam Sahu, appellant number 2, Pavitra, appellant number 4, in the meantime died. Bhattakusta, appellant number 5, he has also died, he is also dead in the meantime. Behra, Nilamani, appellant number 10, and Antar Sahu, appellant number 3, who is also dead. 3, 4, 5 have died in the meantime. Entered into her house. Srinivas was armed with a crowbar. That has not been shipped. Srinivas is the father of the girl who was in love with that Tapan. Then Pavitra, appellant number 8, was armed with a tangi. Baidyanath, appellant number 6, was with a plank. Plank has not been seized at all. Subal, appellant number 7, was armed with a body. When they stood at the inner veranda, I ran away to the house of Ramesh DW3, Ramachandra Behra DW3. Out of fear, my adjoining neighbors from the kitchen room of Ramesh DW3 through window, I saw the accused entered inside the room, dragged Vishwamitra deceased and veranda to the veranda, then courted, and then assaulted him, and Vishwamitra died at the spot. On return, I saw the dead body of Vishwamitra, bleeding injury, and floor was soaked with blood. The accused persons were went away. Cross Simpson. I went through the front door of the accused persons who were at the front side veranda. I had not made any objection. The Srinivas, appellant number 1, Vaidya, appellant number 6, and Subal, appellant number 7, were inside the house and others stood on the veranda. I had not seen any person outside of my house. The window of kitchen room of Ramesh is facing to our house. I had not raised any halla. the male members were present in the village. I had not heard about the love affairs of Uma and Tapan. After death of Vishwamitra, I heard that he and Tapan assaulted each other while running away. I have no chance to see the person who entered into my house. It is not a fact that there is no window in the kitchen room of Ramesh, and I had not seen anything when Vishwamitra died. And Vishwamitra died with assault of Tapan, and I am deposing, falsely implicating, and I am falsely implicating. I have not told this incident anywhere before deposing this court. My lord, here, my lord, so far as PW 5 is concerned, I'll take your lordship to the evidence of DW 3, from whose kitchen window she says that she has seen the occurrence. Well, the DW 3 clearly says that there is no window from his kitchen. And also it is not possible on the part of anybody to see from the kitchen because there is no window, there is no exit. So there is no scope also to see. Well, if your lordship will look at the spot map at this stage, then I'll take a lordship, because she is the most important witness, basing on whose the entire prosecution has relied upon as an eyewitness, and conviction is based. Well, to page 101, this spot map.
Yes. Yes, please. 101.
101. My lord, the top house of Ramesh Pradhan, that DW3. Huh? The kitchen, my lord, also will see left side. Oh, no, sorry. This is the second part is this spot map of the house of the PW 3, 4, and 5. My lord, the kitchen, she was in the kitchen. She says the kitchen. Then she came inside this and again turn right and again to the veranda, and the entrance door is this. So it is she says that she was in the kitchen, hearing Allah and hearing him. She went out and she found through entrance door. She has gone to DW3's house. My lord, it is just not possible to see that the intents of this person to see so many persons when she has categorically says that she has seen from these persons at the entrance person, and specifically when there is no window. The spot map also doesn't say in the window. The 3 exits are there, but the thing is that Lordship will see from the kitchen. If he sees, then the room, Lordship kindly see the room. Bedroom is in the right hand side middle portion, where the deceased was had entered into the bedroom. From bedroom, she was dragged to the veranda, then to the inner courtyard. So she says that she has seen from the bedroom, and bedroom dragging up to the veranda. It is just not possible on the part of anybody to see this bedroom part also. The open courtyard also it's not possible because there is no window. But anyhow, the dragging part is also cannot be accepted because of this spot map itself. Now may I take your lordship to DW3. DW3.
Yes.
Page 84.
Yes.
I know the deceased and the accused Vishwamitra died since long in murder. I know Tinath, he was my western neighbor. Vishwamitra was murdered in the house of Tinath. On the date of occurrence, Sukranti PW5, the wife of Tinath came to my house and told that Vishwamitra and Tapan entered into my house and assaulted each other. I came out and saw all the accused were standing on the danda. I saw Vishwamitra lying dead and Tapan lying with injuries. Then I came back. I was examined by IO. I do not know if accused murdered Vishwamitra. I was inside my house. I had been to the spot after the occurrence took place. There was a meeting in the village. Tapan misbehaved, daughter of Vishwamitra. Not a fact that the accused person staged Vishwamitra on the house of Tinath and deposing falsely. And there is no window facing to the house of Tinath from my kitchen. And on this subject, questions has been declined. And another important aspect that PW5 also says that she is for the first time she is coming to the court, and for the first time she is stating all these things in the court.
What?
So, when specifically there is no window from the kitchen. There is no scope for her to see anything. And specifically on this issue also, the defense has not refused to cross-examine or cross-examination has been declined. So in view of such, the PW5 statement is totally not, my full submission would be that will not be believable. And then you'll also kindly see PW6, the son of the deceased, page 86. I'm sorry, page 66. Page 66.
Yes.
Deceased Vishwamitra is my father. I know all the accused persons. My father was killed 7 years back on the date of occurrence at about 6:30 a.m. My father was cutting wood. His father is the deceased in this case. I was inside the house. My hearing halla, I came out and saw my father chasing Tapan, who died subsequently, and as he had been in love with my sister previously, and all accused following my father. Rohit, appellant number 8, was armed with tangi. Baidyanath, appellant number 6, was armed with wooden body, and the others were holding body. They were shouting to kill my father. My father entered into the house of Tinath Pradhan, PW3. I followed my father, and the accused chased me. I went away. I heard that the accused persons dragged my father from the house of Tinath and killed him. Out of fear, I concealed myself. I went to the spot, and after arrival of police, I saw the dead body of my father at the door. At the door of Tinath Pradhan, PW3. We're residing in Upper Sai. The house focused at located at the distance of 100 yards from my house. Subal, appellant number 7, resides in the Talasai at the distance of 300 meters from my house. The accused, I mean Srinivas, appellant number 1. I saw 40 to 50 persons running behind my father, and my father and Tapan running ahead. The accused persons arrived half an hour after the quarrel between Tapan and my father. My father and Tapan went towards Talasai. Tinath, PW3, resides at Upper Sai. I followed them, persons who were running behind my father. I cannot name the accused and the position of the persons, so we cannot name the accused persons. He said that though he was from the same village, but he cannot name the accused persons following the evening. And he said that 40 to 50 persons were chasing. Accused persons chased me up to my house. Sometime thereafter, somebody told me that accused persons went towards Talasai, but I had not seen this. I had not raised any holla or requested anybody to hold to be held up. Tapan is dead. I was examined by the PS. It is not a fact that I had not stated to the IO that appellant Rohit, appellant number 8, was armed with a wooden plank and Baidar was armed with body. It is not a fact that my father and Tapan together entered into the house of Tinath, and due to assault by Tapan, my father expired. So, my lord, here are two aspects are there. First of all, he has not stated the presence of Rohit and Baidar before the police. And that the wooden plank, he says that appellant number 8, wooden plank, he was holding wooden plank. Wooden plank has not been seized at all. And then I'll also kindly see the other seizure witnesses, as usual, they have not denied the seizure part and all that. Then you'll also kindly see the IO, PW10. May I take a lordship to the, because the evidence questions, no?
Yes.
I'm sorry, my lord, it is page 76. Page 76. Oh, I'm sorry. Oh, I'm sorry. I stand corrected, my lord. My lord, the plank, crowbar has not been seized. Plank has been seized. I'm sorry, my lord. I'm extremely sorry.
All right.
And I'm thankful to my friend who reminded me of my mistake.
All right.
My lord, dear, page 76, my lord, so I can listen.
Yes.
Because page 77, my lord. I arrested accused Baidyanath Sahu on 24/5/90. Accused Baidyanath Sahu is appellant number 6. 24/5/94, who was undergoing treatment at Ongul Hospital as an indoor patient. And on production of escort, I seized the wearing apparel and injury pattern, coding, injury partner. Oh, sorry, he was undergoing treatment at honorable. So the appellant number 6 was also injured, but prosecution has not explained how he sustained injury and all that. Then Lords may kindly see the cross-examination, page 78. It is a fact that Tapan and Umakanti had love affair, due to which prior to incident there was a meeting. The deceased changed Pradyumna. Probably it will be Tapan, wrongly written Pradyumna. And X on the date of occurrence, and the PS case number 26 of 94 was registered against deceased Vishwanath on section 300 summoned by 324, in which final report is submitted. PwC has not stated to me that his mother and wife were present at the house at the time of incident. PwC has also not stated to me that Rohit was armed with wooden plank and Vaidya was armed with a body. It is not a fact that I had not searched the house and accused persons and nothing had recovered from them. It is not a fact that I had not examined. Umakanti is actually PW5, actually wrongly. Sukanti. And Kerali, PW4, Kerali Pradhan. And Biswamitra died due to assault made by Tapan with Tangi and Lati. It is not a fact. So, my lord, before proceeding to defense witness, my lord, only I am submitting, my lord. So far as PW 3, 4, 5 was concerned, they are the total family members. PW 3 is the husband, PW 5 is the wife, and PW 4 is the mother of PW 3. Well, PW 3 doesn't say anything about PW's existing presence of PWs 4 and 5. And PW 4 and 5 coming for the first time to the court and deposing something. And PW4 I need not repeat, my lord, PW4 pattern. And PW5, my lord, I need not repeat, but PW5, the thing is that PW5 presence was not stated by the PW3 before the police. That is a very strong suspicion. And another thing is that PW5's statement for the first time in court without it, that is also totally, they cannot. Then, my lord, may kindly see the DW defense witness, page 80, DW1. Para 2. On the date of occurrence at about page 80, my lord, 80.
Yes.
Lord, page 80, my lord. DW1. Para 2. On the date of occurrence at about 7 a.m., Tapan came running and Biswamitra chased him with Tangia. They came running to my shop. Biswamitra deceased, dealt a Tangia blow to the shoulder of Tapan. I tried to intervene, but Biswamitra threatened to kill me. So I left Tapan. Vaidya Sahu, appellant number 6, came there. When he tried to intervene, Biswamitra dealt a Tangi blow to him. Vaidyanathan ran away. Vaidyanathan, who was injured in the hospital, he was being treated for the injury in the hospital, as stated by the IO, my lord. Vaidya, appellant number 6, ran away to his house and Tapan ran away. Biswamitra chased him. They entered into the house of Tinath Pradhan, PW3. Soon thereafter, all the accused persons came there. I saw Biswamitra lying dead and Tapan lying with bleeding injury at the courtyard and Tinath Pradhan, courtyard of Tinath Pradhan. All the accused persons there, reached there. Tinath was absent in the house. His wife was also not in the house. It is also not a fact that the accused persons killed Biswamitra. DSP asked me about the case. Police seized a broadstand bag from my shop. Not relevant. Then consumption is not very relevant, my lord. I can only one paragraph if I can read it, but it is not very relevant. Let's kindly see DW2, in whose shop PW3 was sitting at the time of occurrence. I know all the accused persons. Page 82. I know all the accused and the deceased. Biswamitra was murdered 7 years back. He was killed by Tapan. I had a beetle shop near the house of Tinath PW3. On the date of occurrence, Tinath was at my shop. The accused never asked Tinath to bring out Biswamitra from his house. At 7 a.m., I heard Hala that Biswamitra was killed by Tapan. I went to the spot and saw Biswamitra lying dead in the courtyard. Tinath, the accused persons, removed Tapan with a bleeding injury and taken to hospital at Anugul. Kasyanson, well, I had no document to show that I had a shop. I have a shop. It is not a fact that I had no shop at the village. A meeting was held in the allegation that Tapan misbehaved the daughter of Biswamitra and nothing could be decided. On the date of occurrence, while Tapan was going to Biswamitra, Biswamitra attacked him with a tangia. It is not a fact that all the accused persons chased Biswamitra and assaulted. Then ballot I told PW3. Though I have read it, but for many people, very small statement ballot. I've read the statement, but for a minute, I'll also kindly read it again. I know the accused persons and so. On the date of occurrence, Sukanti PW5, the wife of Tinath PW3, came to my house and told that Biswamitra and Tapan entered into my house and assaulted each other. I came out and saw all the accused were standing on the danda. I saw Biswamitra lying dead and Tapan lying with injuries. And because I had been to that I have read, my lord, and need not waste a lot of time. Then, my lord, DW4, page 36, page 86.
I have to upload it.
Page 86.
So why don't you just summarize your submission?
My lord, summarize. Only that there are two important aspects, my lord. Besides the statement of witnesses, two important. First of all, not a single MO has been produced in the court. That is a strong ground as per the judgments of the Honorable Apex Court and the judgments of the different courts that were not been produced. So then this most important aspect is the accused statement. But the law is very well settled that accused statement 313 not an empty formality. All the circumstances specifically have to be stated, asked to the accused, and accused must be given chance to reply to the same.
Yeah.
So far as that part is concerned, my lord, let's kindly see accused statement. Let's kindly turn to page 37.
Yes.
All accused persons have been asked same questions and page 37, my lord. That is my point. My lord, it comes out from the evidence of PW5 that you, along with others, entered into the house.
That's okay. You don't have to read it. You don't have to read each of that. Basically, you're saying the same questions have been asked. Yeah.
So circumstances. In my note, I have given the details. But the circumstances which are specifically to be stated, confronted with the accused persons, have not been given.
Right.
The general way they have given this, that is. And in that context, my lord, the married site only, although I have filed cited 3 judgments, but I'll read only one portion of the judgment.
Right.
That is flag 5. Flag 5 of the judgment.
Ashraf Ali.
I had the flag mark for the convenience of lordship.
Yeah, Ashraf Ali.
Yes.
Yes.
Yeah, well, para 21 more kindly listen.
Right.
Page 334.
Right.
Section 313 of the code casts a duty on the court to put an inquiry or trial questions to the accused for the purpose of enabling him to explain any of the circumstances appearing in the evidence against him. It follows as a necessary corollary therefrom that such each material circumstance appearing in the evidence against the accused is required to be put to him specifically, distinctly and separately, and failure to do so amounts to serious irregularity besetting the trial if it is shown that accused was prejudiced. The object of section 313 of the code is to establish a direct dialogue between the court and the accused. If a point on the evidence is important against the accused, then the conviction is intended to be based upon it is right and proper that the accused should be questioned about the matter and be given an opportunity of explaining it when where no specific question has been put by the trial court on an interrogative application, on an inculpatory material in the prosecution with evidence, it would vitiate the trial. Of course, all these are subject rider where they have caused miscarriage of justice or prejudice. This court has expressed a similar view in so and so case. And to section so non-indication of inculpatory material on its relevant facts by a trial court to the accused adds to the vulnerability of the prosecution case. A recording of statement of the accused under section 313 is not purposeless. Then let's kindly turn to next page. The para 18. So para 18. But I need not because that is relating to the referring to para 20. You'll also kindly state come to para 25. Para 25.
Yeah.
What are the question put in that case?
Yeah, that we see.
Then para 26. And rightly content of consider that it can be on that count alone can be conviction set aside. And in this line, my lord, I have cited two other judgments that. Then another, my lord, the on probability and improbability also I have read that your lordship must have read 100 times because your lordship have been hearing criminal appeals number of occasions. So accused statement, your lordship, the accused statement as the my lord, accused statement, your lordship will see from the accused statement. The specific circumstances, there are what are the I have already stated what are the circumstances. Circumstances have not been, specific circumstances have not been put to the accused persons. Some accused person has been that dhoti and lungi, dhoti and something seized from you, but it has not been seized from him, his house, and it has been seized. So many aspects, I need not go into note I have given the in detail. Then my lord, you will also kindly see. And sole question for a minute, page 37, only one sentence, I will not waste a lordship time. Page 37, my lord.
Yes.
This sole question, lordship they came out from the evidence of Pilu that you, along with others, entered into the house of Pilu, the dragged Vishwamitra from a room and assaulted him and Lati, Tangi, and as though he expired. But circumstances have not been. What are the circumstances? I need not repeat, my lord, because your lordship have had it and what is it? And then, my lord, may kindly see the iron ore is not a weapon, it is not a MO. Iron ore has not been seized. Iron ore is not a weapon. Only lathis and tangi was there. And question number 3, it comes out from the evidence of PW3 and 4 that you threatened PW3, asked him to bring out Vishwamitra from his house, and thereafter you and others entered into the house PW3. What do you say? Well, this passage has this particular accused was not threatened by had not threatened PW3, and PW4 was not threatened at all. So my what I will submit, my lord, I need not to go to the other accused persons. Even this next page also, this it came out from the evidence of PW 8 and 10 that PW 10 seized the blood-stained cloth and blood-stained lathi from the house of Srinivas Sahu. So seizure has not been made from his house. Seizure has not, these particular items have not been seized from his house, and it has not been here. And axe and planks have been used. It has not been questioned at all. And when the detailed circumstances I have stated in my note, and same question put to all the accused persons. All the accused persons, as if circumstances against all the accused persons is the same. Then, so my lord, to sum up, my lord, only PW3, I have stated, need not repeat, but PW5 is concerned, my lord. PW4, she named only 3 accused persons. She was the first person who has seen the accused persons. She only named 3 persons. Appellant 6, PW3, only named 3 accused persons. And so far as her eyesight is concerned, her evidence is absolutely not probable here because she is not able to identify her own relations. So what to identify the other villagers, my lord? They are all villagers. Yeah. Then, my lord, PW5, and another circumstance is that she has not stated anything before the police for the first time in court. She's coming and stating this thing before the court. So that is the one aspect, because based on such evidence, the accused persons are prosecuted, and if the appeal is dismissed, then they will be sentenced to undergo the rest of the imprisonment. Then, my lord, accused 5, and accused 5, my lord, PW5. Criminal appeal, after a long time, I am arguing criminal appeal. After a long time, maybe around 5-7 years.
Okay.
Appellant number, PW5, my lord. PW5 absolutely is not with the, our evidence is not in any way is not probable, my lord. So, from probability point of view, she is not believable at all. And basing on that, there may be some, maybe out of confusion, there may be some persons, and they maybe that Tapan and Vishwamitra, both the persons who have died, they have chased with each other or something like that. But the fact that he went inside the house of PW3, brought out drag from the room, and again in the courtyard he was assaulted. This aspect theory is totally appears to be totally prosecution story has been totally advanced in this theory. Only when he could not find that there is no other material witness. Then you'll also kindly see the not a memo, not a single memo has been produced. And that also I've cited a judgment to that extent that is also very much important factor to be considered at the time of hearing appeal. And while
then 313.
Sorry.
Then you have said 313.
313.
Yes, Mr. Right.
Obliged, madam. Appellant 3, 4, 5 have died in the meantime, and you also abated
3, 4, and 5.
3, 4, and 5. Obliged.
May I please, my lords? Of course, I'm required to give a translated copy of the FIR because the FIR is very clear. Not that there is nothing in the FIR. If your lordship permit me, then I will translate it and I will convey your lordship the entire FIR. Because that's the very base genesis of the case. There the case starts. And as my senior has stated that PW3 has not stated. So it is required that FIR should be given to your lordship in a translated form. Should I give it on the next? And also
whatever, sir. We are not stopping you from doing anything, sir. Please. You don't need our permission for arguing your case.
Sir, I have written to the police officer in charge of Jaropada that 10 to 12 days back, Vishwamitra, the deceased, was having some relationship, extramarital relationship with, relationship with Tapan Kumar Sahu. And as because Tapan Kumar Sahu has shown some option behavior towards that daughter of Vishwamitra. So there was an application to the village committee. So the village committee assembled to decide on the issue. But Tapan didn't turn up to attend that meeting. And for that reason, relating to that issue, today, while Vishwamitra Behera, the deceased, was near her house and was cutting firewoods. Then, and Tapan was going by that way, then Vishwamitra, the deceased, seized him.
Correct. With the tongue.
By holding an axe.
Correct.
Thereafter, Srinivas Sahu, Rohit Sahu, Vaidyanath Sahu, Nilamani Sahu, Subal Sahu, and some others, forming an unlawful assembly. These are all accused persons named plus. Inside the village, holding some sticks and tenga and tangia, they chased Vishwamitra on the village road And to save him, Vishwamitra entered into the house of that Trinath Pradhan, Pedal 3 house.
Informant.
And while he found that Trinath Vera was not there inside the house, then the accused persons came near Srinivas. Out of all the accused persons, Srinivas Sahu and Subal Sahu, two accused persons, while the informant was there near the shop of Shatrugna Sahu, they came there and said that you just brought out Vishwamitra from your house, as because he entered into the house. And finding all of them, in a very angry mood, he said that you just take the help of police. Naturally, Trinath Vera should have and has told it rightly. Then Srinivas Sahu, the accused, will teach him a lesson, will teach Vishwamitra a lesson today itself. Saying so, all the accused persons, Srinivas Sahu, Subal Sahu, they entered into my house, the house of Trinath Sahu. And all other accused persons joined both of them, like Baidyanath Sahu, named loss, Rohit Sahu, Nilamani Sahu, Annamane, Sangat Bhari, plus forming an unlawful assembly, they joined them and they entered into the house and dragged Vishwamitra out of the house and assaulted him by means of sticks and weapons like tangia and other weapons that on different parts of the body. And as because he got injury on his person, on different parts of his person, he fell down on the ground and also died there on the spot. So the very genesis of the FIR he has taken the names of the accused person, Trinath Vera, who has been examined as PW3.
Yes.
Madam. Of course, my land senior has read it, but for loss of appreciation, I am reading some parts. At the time, I saw all the accused persons, how it corroborates the FIR story. I know all the accused and to deceive Vishwamitra. I am the informant. Incident took place on 23rd May 1994 at about 8 a.m. near my house. I was sitting at the shop of Shatrugna Sahu. At that time, I saw all the accused chasing Vishwamitra with lathi, and Vishwamitra concealed himself in my house. See, this last theory is coming up now. If suppose 4 and 5 will not, of course 5 will not be dispelled. I am not going to that one. 5 will be believed by your lordship. I saw all the accused persons chasing Vishwamitra with lathi, and Vishwamitra concealed himself in my house. Srivastava was armed with a crowbar and others are armed with lathi. Srinivas and Subal threatened me and asked me to brought out Vishwamitra from my house, that they want to kill him. I advised them to call police and Gramurkhi. Then they joined other accused in our house. As soon as I arrived in my house, my wife and mother told me that the accused persons killed Vishwamitra by entering into our house. My wife and mother were inside the house when the accused persons went there.
Yes.
As soon as I arrived in my house, my wife and my mother told me that accused persons killed Vishwamitra by entering into our house. My wife and mother were inside the house when the accused persons went there. I saw Vishwamitra lying with injury below the inner veranda of the house. His head was fractured and blood was coming out from all over the body. The floor and courtyard were stained with blood. Let's pausing for a moment here. My learned senior has pointed out this part, that regarding the presence of his wife and mother, that has not been reflected in the FIR. Because I am putting a question to myself, it's not required. Because it is quite apparent that wife and mother will be there in the house. They are supposed to be there in the house. If that person has entered into the house to save his life, naturally they have seen it. So it cannot say that that particular aspect has to be written in the FIR.
Right.
FIR is not an encyclopedia, as law says it.
Yeah.
It's very clear on that point. So his head was fractured and blood was coming out from all over his body. The floor and courtyard were stained with blood. Vishwamitra was dead by then. On the spot he died. The accused persons were not at the spot. The lathi stained with blood were lying at the spot. I reported at the PS. Exhibit 2 is the FIR. Exhibit 2/1 is my signature. Police came to the spot and held inquest over the dead body. Prepared the inquest report. Exhibit 3 is the said report. And exhibit 3/1 is my signature. So, from the examination chief, FIR story has been thoroughly corroborated. Whatever he has stated in the FIR, that he has stated before the court. He has stated before the court. Then I am coming to the cross. Umakanti is the daughter of Vishwamitra. Tapan is the son of Srinivas. As they were in love, a meeting was held at the village at the instance of Vishwamitra. I'm reading from the cross plus page 60. I'm reading. Umakanti is the daughter of Vishwamitra. Tapan is the son of Srinivas. As they were in love, a meeting was held at the village at the instance of Vishwamitra. The accused and Vishwamitra resides in different blocks in the village. I have no knowledge about any prior incident prior to this occurrence. I don't remember if I mentioned in my FIR that Vishwamitra chased Tapan with a tangi on the date of incident and assaulted him. I had not seen Tapan at the spot. It's not a fact that I had not mentioned in my FIR that my wife and mother told me that accused persons killed Vishwamitra. It is not a fact that I had not stated the IO that my mother and wife were present. I have examined this. Of course, I have not stated before the IO that wife and mother were present. But it's a question of appreciation that mother and wife, they're supposed to be there in the house. And the shop of Saturna is not in between my house and the house of Srinivas. Some other persons were at the shop, but I don't remember their names. Ramesh and Rabindra are my eastern neighbors. Digambar, plus all these questions have not demolished whatever he has stated in the examination in chief. Very short cross-examination. That is the reason why 313 has become short. Then PW4 plus. An elderly lady has stated, myself and daughter-in-law Sukanti were present at the house. Plus, I'm reading the third line at page 62. Tinnath had been to the shop of Saturna. I was at a cattle shed to remove the cow dung. I saw Subal with body, Vaidya with wooden plank, and Nila without arm. And Subal was shouting to kill Vishwamitra, who entered into our house. Out of fear, I went away. I had not seen the other persons. 5 minutes thereafter, I returned to the house and saw the dead body of Vishwamitra inside my house with bleeding injury. My eyesight was not good for last 10 years, and I was not able to identify immediately even to my relatives. The cattle shed is at a distance of 10 to 14 cubits from my house. It is not a fact that the person to whom I saw were on the front side of my house. Subal, Vaidya and Nila were found at the inner veranda where Vishwamitra was. This one line probably is missing. While Vishwamitra was, then one line is not there. I think that must be available in the LCR. My house consists of 6 rooms. By witnessing the holla, I went away to the backside through Barry. I have not stated these things anywhere before deposing this court. I have not seen any other members inside my house. I returned to my house afternoon. I have not raised any holla out of fear. My son returned to my house after my arrival. Sukanti came afternoon. I heard about the love affairs of Tapan. Plus, this lady is also, elderly lady is also quite truthful. And all were known to her because they belong to one village. They are not unknown. So that she can even identify any of them from their voice, from their body language. And you also may kindly appreciate the time of incident. So many persons have chased another, who to save his life has entered into his house. And so many persons are attacking. It is not possible to give a video presentation about the entire occurrence. Neither the PW3 can give, nor PW4 can give, nor PW5. That is the reason why PW3 has not taken the names of all. But he knows all these persons because they are his co-villagers. They are known to each other. There is no question of disputing the identity of the persons who are assaulting. Plus, P5 is important. Of course, my learned senior has submitted that she has not been examined by the police because that question has not been put to the IO. Exact question has not been put to the IO. But even if law has been well settled, even if he has not been examined, a witness can also examine before the court. And if his testimony will be found to be truthful, then his evidence can be accepted by the honorable court. And so candidly she has stated loss in the chief. Because virtually your will find there is no cross. Only because he was not examined, her entire testimony cannot be discarded. I know that this is Vishwamitra and to all accused. Vishwamitra was murdered 7 years, but I'm reading 64, P5 loss. My mother-in-law was going to cattle shed and my husband had been to the shop of Saturna. Vishwamitra entered to her house from Danda and entered into a bedroom and closed the door from the inside of the room. Srinivas, appellant 1, Vaidya, appellant 6, Rohita, appellant 8, Subal, appellant 7, Himanshu, appellant 9, Gautam, appellant 2, Pavitra, appellant 4, and Bhattakrishna, appellant 5, Nilamani, appellant 10, and Antar, appellant 3, entered into her house. Srinivas was armed with a crowbar. Rohit, appellant 8, was armed with a tangi. Vaidanath is appellant 6 plus, with a plank. Subal was armed with a body. When they stood on the inner veranda, I ran away to the house of Ramesh Chandra Behera out of fear my adjoining neighbor. From the kitchen room of Ramesh through the window, I saw accused entering inside the room and dragged Vishwamitra to veranda, then to the courtyard, and they assaulted him, and Vishwamitra died at the spot. On return, I saw dead body of Vishwamitra with bleeding injury, and the floor was soaked with blood. The accused persons went away. Plus, for a moment, I am taking lordship to the evidence of PW9. Virtually, the person was has been butchered. The doctor who has conducted autopsy, PW9 was at page 71.
Yes. I think just because he has not even argued PW9 and all. I don't think he's attacking the medical evidence.
Medical evidence.
I don't think he's even questioning that.
Yes, yes.
See, he's not questioning that it's a homicidal death.
Yes.
He's not questioning all that.
No. And you'll also will find, so far the appellant 4, 5 are concerned, except a suggestion that he was not examined by the police, no other suggestion has been given. So no plea. Therefrom, again, I am submitting, of course, in the another case, I was making the submission to lordship. When a specific plea is to be advanced, then on that plea, defense is to be late. So there is no specific plea here.
So the prosecution case rests on 3 eyewitnesses. 3, 4, and 5.
Only one eyewitness. 4 and 3 and 4.
5 is also seen.
Yes, 4 and 5.
Only one.
4 and 5.
4 had seen only the 3 persons.
Whatever, sir.
They have not seen the
doing
occurrence.
some mathematical calculation.
No, they have not seen the occurrence. He has not seen the occurrence as per 300. I'm sorry. I'm extremely sorry, madam.
No.
They've seen the occurrence.
Anyway, sir, we have heard you at length.
No,
I'm only asking him. I'm only asking him.
She has taken the names, PW 4, 5, and also PW 3 has taken some names.
Correct.
And 34, is it 3? Convicted under 302 and 34. That is common intention. All have entered, all have dragged, all have conjointly did that crime. And so far as the other aspect is just I am answering what my learned senior has stated. Of course, that the law in 313 statement to avoid violation of principle of natural justice, every question, whatever materials are there, including materials, should be put to the witnesses, accused persons. And plus, even if it is short, but the course it covers the entire materials, whatever including materials, whatever has come up through the deposition of prosecution witnesses. And so far as the chemical examination report, you also will find the connection of the accused persons to the crime. It is very clean. That starts from page 93. That is plus exhibit 21.
So this human blood B is whose blood?
Human blood B. And it is
Matching
dhoti.
the deceased.
Yes. Plus dhoti A, the marked as A, that was Antar accused plus appellant. I'm just telling the name. Made a chart. I'll give a chart saying whose name is that.
No, these dhotis and all taken from the accused.
Yes. Dhoti is Srinivas. And then also dhoti, one was Pavitra. Then D, that is from Gautam. And then E, that is Bhattakrishna. And all that is also Srinivas. I'll give a chart plus after the for your lordship's convenience. And bamboo lathi also carries blood human being. Iron axe also carries blood of group human being. Iron that is iron one iron, maybe piece of iron. That is all that carries also blood of group that is human being. And earth, stained earth, that marked as S, that is also I'm reading from page 95. That is also human being.
All right.
And deceased towel, that is 22, serial 22 plus Roman V, that also human being. So that part also they have not explained. That part they have not said. That clearly connects all the accused persons to the crime. And it is a case of 302 and 34 of the Indian Penal Code. There is common intention plus all of
This
them joined together.
defense stand, if you see in the written submission, which he has handed over, this written submission.
Yes.
Just see the defense stand. They're saying it is Tapan who killed the deceased.
My landlord has given me just now.
No, just see the 2 lines only. Defense stand, it says. First page, the second page. Below facts of the case. It says Tapan killed the deceased.
Yes.
What is your submission? Have they put this suggestion to the IO? In the cross-examination of the IO, have they given the suggestion that Tapan is the one who killed the deceased?
I'm very famous.
And what does he say to that suggestion? If at all? Tapan's father is also examined as a DW. I don't think even his father has been asked that.
Yes. So many persons of that village, they are all involved. So can gain anybody, gain over anyone. Plus, I'll give a small reply on the next date. Plus,
no next date, sir. We have to finish today.
Then I'll give a note. Plus, I'll give a note with all citations also.
Yes, Mr.
I'll examine that IOS evidence.
Yeah. I'm sorry for PW 4 categorically says that she has not seen other accused persons except the persons named.
It's okay, sir. Everybody doesn't have to see everyone. It's not a roll call.
No, then she has not seen it.
If you say, if she had named everyone, you will say so unnatural. That precisely she is able to name everyone.
No. But she has specifically said that I have not seen other accused persons. No, not naming another person, but she said I have not seen other accused persons.
All right.
I have not seen other accused persons.
All right.
The crime
other
scene
persons.
other persons. Was full with days and excitement. The crime scene itself.
In chief, he has stated so. In chief, she has stated so. Other aspects, my lord, I have stated.
Not demolished in the cross.
And
no, you have anything to say about this forensic serological examination?
Serological examination, my lord.
All the weapons, dhoti, everywhere, human blood.
My lord, when the incident takes place, my lord, in the other persons are there. So if the person who carries the dead body also, she's also.
No, they are aggressors.
Also there.
No. Bamboo, lati, everything is black.
No, these things have not been produced for the court. And serological report cannot be accepted when it has been produced for the court. And there is a judgment
not required in the defense. Even if weapon of offense has not been produced for the court, even that will not demolish the evidence of an eyewitness.
And Tappan had also injuries, and exhibit AB that clearly shows that exhibit Tappan had the injuries on his body. And especially appellant number 6, she was treated. One of the evidences that one of the witnesses said that the appellant number 6 was attacked, and appellant number 6 was also in the hospital for 10 days. And that has not been explained by the prosecution at all. And that has been specifically admitted by the PW10 IO that prior to the incident there was a meeting and
prior to the incident.
Wearing apparels, carrying blood itself speaks law.
And X and on the date of occurrence and PS case number 20 registered against the deceased Bishamitra.
No, that's something.
While wearing apparels, carrying blood, that itself speaks that these persons were present
because all the persons. And the thing is,
at the crime.
If at the PW4 statement is able to be, then only 3 appellants are there. Because PW4. PW4 3 is not there. PW4 is also not the eyewitness. She is the post-occurrence, immediate post-occurrence witness, but not the eyewitness. Eyewitness is PW5, and so far PW5 is concerned, I have categorically stated that absolutely her statement is not believable because she had seen from DW3's house and DW3's kitchen, and kitchen there is no window from kitchen. That has been established from the spot map as well as from the statement of the DW3. So that itself is sufficient to discard her statement.
All right.
Obliged.
Orders reserved. See, it will be open to the counsel for the state to file his written note of submissions within 1 week.
Diploma.
All right. I think one was. He was there. I thought he will call out because he was there.
Pastor matter item number 1.
Yes. Item number 1, it will take some time. Should I begin at this hour? It is a 302 murder case. I have given a small note. I will, in the next date, your Lordship may keep it to tomorrow. I will first hour, I will finish it. Oh, sorry. I have given a small note.
Let's see that note, sir. 1 minute. Let's see that note.
Out of 3 accused persons not here, 2 were released on bail. One has undergone the sentence.
And also been released.
Now he has also been released from jail.
But you're still pressing his appeal.
No, other 2 accused persons, they have been convicted also.
Right. Right.
Appellant number 3 was sentenced to. His bail was refused by this honorable court. So he has in the meantime undergone his sentence. Right. And now he has been released from bail. The other 2, he was alleged to be holding the deadly weapon.
Prematurely released.
Right.
So far, the prosecution case in brief is that.
So the 3, 4, 5, and 10 are the 4 eyewitnesses, correct?
Yes, they are all brothers of the deceased.
Correct.
And a close scrutiny and reading of their evidence will go to show one is contradicting the other.
Right.
As if there is no eyewitness, and these 2 fellows have been shown to have been assaulted with sticks. And if your Lordship will, I have given the analysis. If I will place minutes, I will place them. And one of the brother, namely Kalyan, who had tried to open the door from which was bolted.
So next Thursday we'll start this. We'll start this next Thursday.
Obliged.
All right.
I will be my Lordship. Note is I have given everything, but little I must explain to your Lordship.
All right.
For my satisfaction.
Naturally. All right. indisposed.
Mr. Srijit Mahanti.
Yes, it's Srijit Mahanti.
Right. List on 28th July at 4 p.m.
Obliged.
Right.
With the lordship permission, may I make a mention? In the last bench, of course, that matter, that the appellant has died in one matter. So,
Which
died was. In the last matter, last bench, one appellant has died in item 5.
Item 5?
Yes, please. I will give the document, please.
Oh, so that can be disposed of?
Yes, please.
So 5 we can make a note. Weekly 5, is it?
Just now I'm filing this.
Weekly 5. All right. We'll make a.
People obliged.
All right.